The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel.
Good morning, Your Honor.
We're happy to hear argument in our first case. And if you would identify yourselves just so that we're sure exactly who you are when you speak.
Excuse me, but Mr. Ashmore and Ms. Cox, if you will turn off your video and mute your microphones, please.
Good morning, Your Honor.
I apologize, but should I mute my mic so that you don't hear my rustling of papers or anything?
I think we're ready to begin, counsel.
Very good. Thank you. Good morning, Your Honors. My name is Susan Baker Manning of Morgan Lewis. May it please the court. I represent Petitioner Miguel Aravello Quintaro this morning. The BIA erroneously affirmed an order to remove Mr. Aravello on the sole ground that a particular social group based on current gang membership is not cognizable. And the government invites this court to err by doing the same. That issue was not properly before the BIA, and respectfully, it is not before the court today. Rather, this case should be remanded to the immigration judge because neither the BIA nor the IJ have ever addressed the merits of Mr. Aravello's actual withholding claim. And the BIA decision under review is wrong on both the law and the facts. If I may, I'd like to focus on three particular forms of error in the BIA's 2019 decision. First, the BIA erred in finding that Mr. Aravello attempted to assert a new particular social group on appeal. To the contrary, the record is quite clear that Mr. Aravello tied his fear of persecution to his status as a former gang member. And the record is also indicates that he tied his fear to his cousin who had been brutally murdered by the gang. And if—
What is the, excuse me, counsel, what's the evidence with respect to the cousin?
The evidence with respect to that it was raised or something So,
and that it is a viable social group.
Well, so several things on that, Your Honor. With respect to whether Mr. Aravello put the IJ on appropriate notice that his claim related to his cousin, if you look at the application form itself, you know, we have these very small boxes and there's not a lot of room to write in there. But what Mr. Aravello devoted, I would say probably the majority of the text he put there too, was discussion of his cousin and referencing how his cousin had been murdered for leaving the gang. During his testimony, he was asked why he feared being harmed if he was returned to El Salvador. The first thing he answered was a statement that he had been threatened with his cousin. So he is certainly, I think it's probably fair to say he's spending more of his time talking about his fear of being murdered by the gang as punishment for leaving them. He is repeatedly and consistently also tying his fear to his relationship to his cousin. And in terms of whether family is a viable particular social group, you know, that I think there are a number of cases that have recognized that a family is a potentially viable social group. Obviously, it has to satisfy all of the basic requirements. And it's not an issue that the BIA or the IJ have ever addressed in this case, and it would be appropriate for them to do so on remand.
Ms. Manning, I take it, at least the way I read the record, is that there should be a claim that the IJ failed to fulfill her duty to develop the record, and I take it by your answer that you agree. What does that duty look like in practice? In other words, what would we tell an IJ if were to send the case back? This is what you need to do.
Well, I'll use this case as an example. if this case is remanded to the immigration judge, what she will need to do is to genuinely explore what Mr. Aravello's particular social group is. In this case, he was simply never asked what his particular social group is. And I'm not suggesting that it would be sufficient to ask a pro se applicant, Mr. Aravello, what is your particular social group? Because that sort of legal term of art is not, that's not fair game to put it in those stark terms to a pro se applicant. But
well, wouldn't that be somewhat differentiating if we sent it back? I'm assuming you representing him on appeal. I don't know what would happen if he goes back, but he was pro se the first time.
correct.
When he goes up, and so Judge Floyd's question goes to really, in this circuit, what is the duty of the IJ to develop the record? That's a fundamental question here, because if you look at the record just in and of itself, I'm not sure he ever articulates what this group is. And he's limited in English, so that's kind of from your perspective. But the question that we face is, what is his duty and what does it look like? Now, in terms of when it goes back, if he's represented, then the question comes, is that a different type of situation? Someone who's pro se as opposed to being represented, that the IGA, in terms of the duty of the IGA. So those are the questions we have to grapple with, I think, in this appeal, at least initially.
I understood, Your Honor, and I think that's right. And I know you have another case that touches on these issues as well. I think that here, once Mr.
Yours
Aravello
doesn't just touch on it. Your case is on all fours with it. This is not a touch-on issue type thing, from what I can see. So that's why I'm asking you to articulate at least that here.
Sure, fair enough, Your Honor. So I think when the case goes back, the immigration judge has a duty to develop the record. The BIA has clearly said that in matter of JFF, among other places. I think that in practical terms, what it means is that when a pro se applicant comes in, testifies about the nature and source of his or her fear of future persecution, they need to, the IJ needs to come in and ask questions. Who exactly are you afraid of? Why are you afraid of them? Why are they going to hurt you? Is anybody else going to hurt you? That last is, it's sort of deposition 101. You need to ask all the questions to make sure you've got a complete record.
Well, counsel, I think that goes to what's underlying my colleague's questions. Does the IJ have a responsibility to help the pro se litigant? Is that what you're saying?
I don't think the IJ has a duty to help the pro se litigant. There's some concern that the IJ is somehow conscripted as an advocate, and that is absolutely not what we are suggesting. The IJ simply has to get the facts out on the record and asking things like, why are you afraid? Who exactly are you afraid of?
In other words, does he have to help the applicant make the best possible case by getting these things out? Is that the standard? What we're looking for is how we would instruct.
Sure,
the IJ.
sure. I think what the IJ has to do is anytime there is enough information to sort of put the IJ on fair notice. Again, we're talking about there are only two immigration law experts in the room, the IJ and the DHS attorney. If there is something factually that the applicant puts forward that's sufficient to suggest a particular social group, and I don't mean, turn it upside down, and squint at it, but if it really is there on the record, the IJ should be asking the questions, what they're afraid of, why they're afraid of it, ask questions that get at immutability, particularity, social distinction. The IJ should go through all of those steps, not to help the applicant, but simply to make sure that the information is there on the record from which the BIA and ultimately this court on appeal can make the legal determinations about whether there is or is not a viable claim. But that appellate review goes nowhere unless the IJ both makes that record, and I do think the duty is enhanced somewhat in cases involving a pro se applicant.
Let me ask you about that, because I don't know, how many of these immigration cases have you done?
A decent number. Certainly not as many as others, but a decent number.
Well, we see a decent number too, and I would say that the representation is often not of the quality that you are giving this person. And so do we make a more, do we give the pro se person more benefit? And if you have a lawyer, the IJ doesn't have these responsibilities? Because that would seem to me to be really, on the whole, bad for applicants.
No, I think that's right. And again, the BIA has noted that the immigration judge has a general duty to make sure the record is clear and that all of the issues are touched upon both in the record and in their opinion. And your sister circuits, the Second Circuit, the Ninth Circuit, I believe the Eighth Circuit, all of them have talked about an enhanced duty as to pro se applicants. But that is not, I don't think that's some sort of bright line. I think that the duty is there to get it on the record. And to the extent that a pro se applicant simply requires a little bit more work to discharge that basic duty to ensure that the record is fulsome enough so that we can analyze these issues on appeal, to the extent that a pro se applicant necessarily requires a little bit more, then they do. But that's just the nature of the situation.
What creates this duty? Is it statutory or constitutional?
I believe the BIA, regards it as part and parcel of their statutory obligations.
Well, what are you saying to us?
I suppose I'm saying that I think the BIA is right. I do think that it is part of the sort of general duty to ensure that eligible applicants are in fact granted asylum, withholding, or CAT as appropriate. The purpose of the immigration system and the immigration judge, the BIA, it's not their job to weed people out, of course. It is their job to determine who is and who is not properly eligible for protection based on the law. That necessarily
Judge Motz's question is fundamentally necessary for us to decide. What essentially we're asking is this a due process violation? Some of the circuits, or a lot of the circuits, have held that, or is it, as you seem to want to say, it's a legal error? That maybe the difference is not that great, but at least the question is whether it's a constitutional one, of constitutional approach, or is it simply a legal error in terms of the duty to develop this record? So the question is, how do you characterize this violation by the IJ to not develop the record?
I believe it is a failure in the IJ's, statutory duties. I think Your Honor is also correct in that there are certainly due process issues here. We haven't made a due process claim per se. I think we've couched this more in terms of the IJ.
I'm not saying that due process, into making that decision. I'm simply saying there are a number of circuits that have held that.
That's
and
correct.
My question is, how do you analyze this, and what is this violation? If there is a violation, a duty to do it, then what is it?
So I do think that Your Honor is correct. There are a number of circuits that have analyzed this in a due process lens, and I certainly think that is correct. There is a duty to ensure that the applicant, even a pro se applicant who is unaware of the relevant legal tests, any of the legalese, any of these issues, that they at least have the opportunity to present evidence that would touch on all of the relevant elements of the claim. In other words, they're simply asked the question. All the IJ has to do is ask the basic questions that should elicit the relevant information. You're never going to get a pro se applicant who says, well, Madam Immigration Judge, my particular social group is blank, 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 blank. That's not going to happen, and of course not what anyone would expect. But as long as the immigration judge solicits the relevant information by just asking the questions that touch on the relevant points, then I think the immigration judge will at least have it fulfilled their minimum duty to.
Ms. Manning, what we should do, would it be akin to how we handle pro se litigants, for example, in pleadings? We give them, there's not as high a burden on them for pleading purposes. Is that something that
Exactly.
We should look at?
Exactly so, Your Honor. In both the Article 3 courts and before agencies in these kinds of proceedings, the pro se applicant should be, given the benefit of the doubt, you will. Their testimony should be construed. I'm
But
sorry.
see, Ms. Manning, my problem with that is the one that I just told you about, is that I think actually in a fair number of these cases, you'd be the petitioner would be better off without the representation that he gets.
Well,
So if we advantage the pro se person over him, that seems to me unfair.
I think that depends on how you interpret matter of WYC and its requirement about the sort of strict delineation of the particular social group. How strict is a question that case doesn't really answer. And I think Your Honor certainly could touch on whether it is a stricter standard for someone who is sort of well represented by counsel, or whether it's sort of one standard for what level of strictness is. I think your Honor's point is well taken. But again,
what's the solution?
I
hear you. I think we agree on that. But do we still favor the pro se applicant?
I think we do in terms of understanding what the facts are that they have put forward and what is the legal implication of those facts. I see Your Honor shaking your head. So
well, I guess I've seen in 25 years too many of these cases where the representation is so terrible, right, that I honestly think that the person would be better off.
Understood. I'm happy to go on. I'm a little bit over my time, but I'm happy to
Sure.
continue.
I've taken up some of your time. You go ahead.
No problem.
My colleagues may have some questions. No.
I don't.
Well, I do want to say with regard to where Judge Martz is going on it, it certainly is the instance that we see bad lawyers in cases. Of course, the issue here is really dealing with pro se, and the idea of the concept that perhaps if you're pro se, you're better off. Maybe that's not so foreign to us when we think about Anders cases, which an Anders brief would be submitted and no one has really brought up anything, and the court has a duty to then comb through the record, and it, to some extent, that's really kind of better than being represented, because you're not limited to those things brought up by the counsel. But in this instance, it really comes down to, it goes back to the constitutional versus legal era aspect of it and the duty of the IJ. So, ponder that a little bit when you are thinking about the answers on return, because I think this is a very critical question here in terms of the pro se litigant as opposed to one who is represented, because even knowing what a particular social group, that's hard for lawyers and it's hard for judges, much less someone who barely speaks English. And it has a limited understanding. And so there are certain duties that I think that an IJ probably does have, but just think about that.
Yes, sir. Thank you.
Thank you. Maybe we can hear from the government then. Ms. Lee?
Yes, please, the court. Oh, there it goes. The time. Jenny Lee on behalf of the respondent, the Attorney General of the United States. The court should deny the petition for review because substantial evidence supports the agency's denial of petitioner's applications for withholding and cat protection. First, I'm going to jump into the question that the court has asked a lot of petitioner's counsel about with regard to the immigration judge's duty. The question is, did the immigration judge do her duty in this case? And the answer is yes. She did everything that petitioner's counsel was asking that she do. She asked questions, she listened to his testimony, and she developed the record. She asked follow-up question after follow-up question after follow-up question to figure out what was his fear, who did he fear? And the amicus group and petitioner's counsel think that the immigration judge needed to ask further questions about particularity and social distinction. But in this case, the testimony, petitioner's testimony, and the objective evidence was very clear that he was a current member of a gang. So once we know that that group is not immutable, there's no need for the immigration judge to continue and ask further questions about particularity of social distinction.
Counsel, I'm not so sure it is so clear that his testimony was he was a current member of the gang. And I wondered if you accept, for purposes of appellate review, that the IJ found the petitioner credible.
So, although, yes, the government accepts that the petitioner was credible for the court's review. The board assumed that the petitioner was credible. But even if an alien is credible under the burden of proof statute, the petitioner would still have to show that his testimony was credible, persuasive, and supported by specific facts. In addition, the immigration judge, in determining the burden of proof, is allowed to look at the objective evidence.
And I understand that, but I go back to credible. What else has to be done? I thought credibility was one thing. Okay, there can be other evidence in the record, but you say that there's some further showing that would somehow, I gathered from your answer, lessen the force of the credibility holding?
Yes, Your Honor. So if we go to the burden of proof statute at 8 U.S.C. 1229 AC4, AC4B, sustaining the burden of proof, about midway in the paragraph, it states that in evaluating the testimony of the applicant or other witnesses in support of
We
the
can't hear
application-
you, I don't think. I can't anyway. I can't hear you. You have to talk louder.
Oh, I apologize. I feel like I'm talking loud enough. Can you hear me now? Okay. So on 8 U.S.C. 1229 AC4B, which is the sustaining the burden statute, it indicates that the immigration judge will determine whether or not the testimony is credible, is persuasive, and refers to specific facts sufficient to demonstrate that the applicant has satisfied the applicant's burden of proof. In determining whether the applicant has met such burden, the immigration judge shall weigh the credible testimony along with other evidence of record. Now, having said that, let's look at the record in this case. The petitioner never said that he was a former member. Instead, he said that he was leaving. If we look at the record, in his asylum application, he indicates, I was part of them back in my country. But let's look at his testimony and the timeline. On the record at 170, he said he was, quote, considered a member, end of quote, starting in September of 2012. At 171 to 172, he said that he wanted to leave the gang, and then they threatened him and they beat him for a minute. And he also said at the end of September of 2012, a man from prison calls him. But then what happened afterwards? From the end of 2012 and June 1st of 2013 when he left, he had no more problems with the gang because he did everything the gang told him to do, which was exactly what he was doing before he was threatened by the gang. So in the gang's mind, he was still a member. Now, let's go on to his other testimony. Going to 184, question, did you ever tell them you had left the gang? His answer, never. Question, so is it fair to say that officially at the day and point in time you left El Salvador, you were still an official member of MS-13? Well, maybe you might think that. Next question, 184, when did you stop being an official member of MS-13? Well, I decided when I left the country, I decided to leave the gang completely, absolutely. Then the next question on 185, did you ever communicate to the gang that you were out of the gang? His answer was no. Then couple this with his testimony about his friends in the United States. He testified that he did not know any MS-13 members in the United States, but he conceded, quote, the friends that I hung out with, well, all of them, I didn't know if they belonged to this or that. This is at 186. And at 187, he added that when he had no money and was homeless, quote, I went and these people that I thought were friends, and I thought they didn't belong to anything, so I give them my friendship, and at the end of the day, they involved me in all of that. 187.
So let me ask the question to you where you're going with this. It seems as though you are arguing that in order to be able to indicate you left the game, you have to directly confronted them and told MS-13, you want to leave the game. But the record does show he had indicated that he wanted to leave. He in fact did leave, and that as a result of that, there's testimony that they considered him to be a deserter, and went after it. There's all kinds of information on that. So are you saying that a person has to state unequivocally that they inform the particular group they want to leave in order to be able to obtain this benefit of saying that they are seeking and to threatening him because of his indication?
No, Your Honor, that would not make any sense. But in this case,
that's what I thought.
On this case and on this record, based on his activities in the United States, and his own testimony about his friends, and then let's go to the objective evidence. DHS's I-213 record of inadmissible alien indicated that he was, quote, a suspected MS-13 gang associate. Petitioner in this case was arrested with 3 other people in a vacant apartment by Prince George County's police department. And they suspected, they actually had him interviewed by the gang field unit, and a detective specifically confirmed through a past proven reliable source of information that Arevalo Quinteros, Miguel Angel, and another person that he was arrested with at that apartment are active gang associates of MS-13.
So with all of that, does the record reflect, and I don't seem to find it anywhere, that the immigration judge ever explained to him what a particular social group is?
The immigration judge did not explain to him what a particular social group is, but
did she ever even mention the concept of what it is?
Your Honor, the immigration judge did not have to, because through her questions, she asked him, what were you afraid of? Why were you afraid of leaving? What happened? Based on
But you don't think she has a duty to tell him, explain what a particular social group is?
No, because a person who's leaving their country knows why they're leaving if they're in fear for their life. You don't have
But don't you recognize that particular social group are words of art? Before I did these cases, I didn't know what it meant.
It is a legal term of art, but even though the term is a legal art, the concept should be simple. For example, if I was a transgender person coming from another country, I can say, this is why I'm afraid. And, it's very clear that that was the basis of their fear. So what we're asking aliens, especially, in the pro se context, is to tell us, why are you afraid to go back to your country? And the immigration judge in the pro se context is to compare those fears that they articulate with the legal standards. And that is exactly what the immigration judge did here. And if we talk about numbers, as according to Track Immigration, there are over 1.27 million pending immigration cases in this country. And I'm not exactly sure what the number relates to detention facilities, but between 2000 and 2017, only about 10 to 30% of those aliens were represented in the detention facilities. So what Petitioners Council and the amicus group is asking for is that if you are pro se, then the immigration judges somehow have to further develop the record, because the government's position here is that the immigration judge did exactly what she was supposed to do. She developed the record, and I just recited for about 5-10 minutes how that record was developed. So if you look at the record, the substantial evidence indicates that he was a current gang member who was threatened for trying to leave. Now, if the evidence indicates that he left because he was no longer there, and so somehow from that we get former, that's not the standard. Simply because we can have two conclusions from the evidence, that does not mean that the agency's decision is not supported by substantial evidence.
But he was found credible.
Yes,
You don't dispute that. You really can't dispute it.
I don't dispute that, and I don't dispute that. And in fact, when the immigration judge's determination, the alternative, like first determination was that he was not credible, and the alternative determination was on his particular social group. She said, even if some of respondents' testimony were taken as credible, and it were believed that he was threatened for wanting to leave the gang, he explained he never told gang members he was leaving and simply left for the United States. He was
Counsel, that's why I asked you if you accepted that the IJ had found him credible. Do
Yes,
you agree with you? Not partially credible, credible.
Yes, the immigration judge
Yes.
found that his testimony was, parts of it was, in the alternative determination, she found that his testimony was credible. And again, we have to go look at the burden statute, which says we have to look at all of the evidence, which is what the immigration judge did in this case. And then moving on to, I guess, the final point, which is Pat, his protection, his application for protection under the Convention Against Torture. The applicant has a duty to demonstrate a clear probability that he will be tortured.
Before you go to that, I want to at least make sure I'm clear in terms of your view on the pro se applicant. And I know you stated in your brief, and there seems to have been, Judge Marks had asked the question of your opposing counsel, but is it your position that basically the immigration judge doesn't have to do anything to help the pro se because the burden of proof is on him to do this, on the applicant? Is that your position?
No, Your Honor. The immigration judge's duty is to develop the record, which is what she did in this case. And to develop the record, if you have a pro se applicant, you have to ask them follow-up questions. Why are you afraid to go back to the question and ask follow-up question?
So maybe that goes into the question then is, what do you mean by help them develop the record? I mean, you do state in your brief that they're not to be advocates, but how is this different? Do you view it to be somewhat of a different duty when you have a pro se applicant, as has been the case in federal court? We are asked to liberally construe pro se complaints. In Social Security type cases, the ALJs are asked to, I guess the word would be help the applicants who are pro se in a matter. And here, as Judge Motz has alluded to, defining what a particular social group is not is more of a term of a legal term. I mean, it's a difficult concept. And yet I think you indicated to me that she didn't have a duty to tell him what that is, what a particular social group is. Is that your position?
My position is that the immigration judge does not have a duty to create the applicant's claim for him. So in this case,
that's not my question, though. I would have asked that question. That sounds like a good question. My question is, did she have a duty under this situation to explain, or at least what a personal, what a particular social group is? I mean, that's an interesting question about creating a record, but that's not what I asked. So answer that question, if you will.
The immigration judge does not have a duty to explain what a particular social group is. Instead,
okay, then I got your answer.
What the immigration judge's duty is to develop the record and match it with the facts, which is exactly what's done in this case.
Well, let's just pursue that a minute. So she's developing the record, and part of the record is determining what the claims are. And so is she, or is the IJ to say, do you claim to be in a particular social group? Is that what she's supposed to say?
No, that would be a legal term of art, and so the alien might not know what that means.
Right.
Obviously.
So how would she develop that record?
So what she says is, why are you afraid to go back to your country? Who are you afraid of? And that was what was
maybe this case comes down to whether the IJ fulfilled her duty to develop the record, because you feel there is a duty to develop the record, right? Ma'am?
Yes, Your Honor. Yes, the immigration judge does have a duty to develop the record.
Okay.
So moving on to the Convention Against Torture, an applicant for cat protection has the duty to demonstrate a clear probability that he will be tortured with government acquiescence. And you can't do that with just evidence of general country conditions. Nothing in his application or his testimony indicated that he had a particularized threat from vigilante groups or from the Salvadoran authorities. If you look at his application, the question is, are you afraid that you would be subject to torture in your home country? If yes, explain why you're afraid. His answer was El Salvador, but the only thing I have in life is still back in there. My mom and dad, as a human being, I miss them a lot. Again, there's nothing about vigilante groups or authorities. Now let's look at his testimony. The immigration judge asked, when you lived in El Salvador, did you ever have any problems with the police or other government authorities? His answer was yes. I did have a problem, and he explained, well, I did have a problem with the authorities of El Salvador because they caught me with the motorcycle that belonged to them. And at 177, he explains that he was in prison for 3 days and released because he was considered a student. And then the immigration judge said, is there anything else you wanted to tell me about any other encounters you had with the police or other authorities? His answer was, that's the only problem I had when I was in El Salvador. Other than that, I have no other problem. So his own testimony does not claim that he had fears from the authority, that he feared torture from authorities or vigilante groups. Now compare that.
So do this. I mean, let me point you at least something I think that would be important if you discuss it with me and with the court. We have a case, Rodriguez Harris versus Whitaker. Are you familiar with this case? Of course.
I'm very familiar with it, Your Honor.
Tell me, why doesn't that go against your argument here with regard to this particular issue?
Yes, Your Honor. In Rodriguez Arias, the petitioner in that case specifically testified that because of his gangs, that he expected to be targeted by violent gangs and by vigilante groups and by the police. In addition, he provided expert witnesses about how gang members or suspected gang members routinely experience extreme violence in El Salvador at the hands of other gangs, numerous vigilante groups, and police forces. In this case, we just don't have that type of evidence. So again, under the substantial evidence record, you look to see where does the evidence fall. And here the evidence, substantial evidence supports the agency's conclusion that he did not have, that he failed to show a clear probability of torture in El Salvador. And since I have a little bit of time, I wanted to talk about his particular social group with regard to his family. Petitioner's counsel mentioned that in his asylum application, he indicated that he mentioned his cousin a lot. Well, let's look at that question. And this is at page 347 of the record. The question is, have you, your family, or close friends or colleagues ever experienced harm or mistreatment or threats in the past by anyone? That does not ask, why are you afraid? Which would be, if he's saying that that he belongs to a particular social group consisting of his cousin, the question would be, why? Then let's look at his testimony. When he testified, he said that he was threatened with his cousin and that they killed him, but he didn't say that that was why he was afraid. Instead, it was just a recitation as to other reasons why he feared the gang. I see my time is up, and with that, I thank the court for its time, and I rest on the government's brief. Thank you.
Thank you. Ms. Manning, you got rebuttal?
Yes, Your Honor. Just a few points, if I may. First, on this question that my colleague addressed about whether my client made it clear in the room, in the hearing, whether he was seeking protection because he had left the gang without permission. I think it was crystal clear. I think the application shows that. I think the testimony shows that. But the way we know it was clear is because that's the issue that the government attorney addressed in closing. If I may direct your honors to page 191 of the record, page 48 of the transcript, lines 11 through 14, or 12 through 14. The government attorney says, and I quote, "There's not a clear probability that if he returned to El Salvador, he would suffer persecution on account of being a former gang member, since the government's position is he's clearly a current gang member." Now, the government's arguing that he is not factually a former gang member, but the government is also acknowledging that the whole point that my client is making, the reason he's seeking protection, is because he is a former gang member who left without permission. So I don't think they're, given that government acknowledgement, I honestly, I don't think there can be any sort of serious doubt that he at least put forward enough information to put everyone on notice of the nature of his claim in that sense.
Ms. Manning, can you tell me whether there was more than one source of potential torture? And if there was, did the immigration judge aggregate that testimony?
No, Your Honor, I don't think that the immigration judge aggregated the testimony as required by the opinion you authored in Rodriguez Arias.
Well, first of all, you got to tell me: is there more than one source of future torture
yes.
in your mind?
Yes, I
what
believe
is
there is. So the country conditions evidence explains in some detail how rival gang members will prey on certainly their rival gangs, but particularly former gang members who no longer have the protection of the gang, frankly. There's extensive evidence of extrajudicial killings of gang members and former gang members by the police. There's evidence of vigilante death squads in El Salvador. None of that is addressed in any way in the IJ's decision, and frankly, given that the decision was issued a day after the hearing, not at all clear that that was actually genuinely considered. Now, it is correct that my client didn't identify, say, I'm afraid of being tortured by rival gangs, the police, and vigilante death squads. But there is not a subjective component to cat protection. He doesn't need to say that he is subjectively afraid of particular gangs if the evidence shows that there is, in fact, an appropriate claim based on those other sources of risk.
Did the IJ consider country conditions at all?
It does not appear that she, well, I should take that back. There is a brief mention of country conditions in the opinion, I believe, but it is not at all clear what she considered about country conditions, or whether it was, again, it was opinions issued a day later after it was first entered in evidence. So not clear that she actually considered it in any sort of significant way at all. If I may address Judge Wynn's question earlier, in terms of the source of the duty to ensure that pro se applicants, if I may put it colloquially, will have a fair shot. There is, I believe, a statutory component to that duty. There is absolutely also a due process component to that duty. It's been recognized that the Fifth Amendment due process requires that removal hearings be fundamentally fair. That is, among other places, the Supreme Court's Flores decision, 507 U.S. at 306. It cannot be fundamentally fair if the IJ and the DHS attorney are well aware of the various legal complexities and the terms of art, including particular social group, what the tests are, what the requirements are, and the applicant, as in this case, just has no idea. There is no way that my client had any idea he was supposed to articulate a particular social group, much less what that meant in any level of detail at all. So he simply has to be asked the questions. That duty of the IJ to make sure that the hearing is fundamentally fair requires a level of follow-up that we did not see here.
Well, is that duty greater than the IJ's statutory duty to develop the record?
I think the due process component is yes, because when an individual is represented.
I'm sorry. When would you have a situation where the IJ had sufficiently developed the record, but there was still a fundamentally unfair and therefore a constitutional violation in your view?
Oh, I'm afraid I'd have to think about it. I think there could be any number of possibilities, frankly.
So does this only happen if you have a pro se
No, absolutely not.
claimant?
No,
Well, then if that's so, are we judging the quality of the representation that the person is getting? So if you have a good lawyer, we hold you to one standard, and if you have a bad lawyer or you are pro se, you get a benefit of a better standard?
I think either way, the hearing has to be fundamentally fair. That sort of due process minimum of fundamental fairness. If the lawyer is so poor, so incompetent, what have you, that he or she does not do enough to make the hearing fundamentally fair, the IJ, has that duty regardless of what the attorney is or is not doing. I think we will assume, and I think very reasonably assume, that in pro se cases, a good amount of the time, the IJ is going to have to do more work, certainly than they would have to do if the applicant is represented by competent counsel.
Well, let me ask you this: in this case,
yes,
in this case, the case we have in front of us, if the IJ had performed the duty according to you and fully developed the record, as you say the IJ must,
yes.
Would there be something else the IJ had to do because of the Constitution?
I think in terms of the issue, if I'm understanding Your Honor's question correctly, I think once the IJ ensures that the record is adequately developed, that is, there's enough information from which both the BIA and this court could judge whether there is, in this case, a particular social group based on what the client is actually claiming, not this other imposed social group. But if there's enough there to assess that, in all of its various elements and all of its, frankly, nuance, because it's a complicated issue, then that would be enough. But we just didn't get anywhere close to that in this case. Whether there would be other duties, for example, the IJ's duty to actually address each and every issue, there's no discussion really of particular social group. There's a footnote that kind of alludes to it, but doesn't really address the issues, doesn't analyze it in any way. And there's sort of nothing to work with on appeal. That too, is something the IJ would need to do. That's both statutory, it would be an abuse of discretion. And at some point you could get so poor that there would also be this fundamental fairness issue.
Thank you.
Thank you, Your Honors.
The case is submitted. Unless do my colleagues have any further questions?
No further questions.
No.
Thank you very much, counsel. We appreciate your argument. Ms. Manning, are you court appointed?
No, ma'am, we are not. We are pro bono, but we are not court appointed.
Well, we appreciate your efforts. You did a fine job for your client. Thank you. So we go directly to the next case, is that right? There we go. Good morning, counsel. In our second case, maybe you just be sure and identify yourself and for who you represent when you begin.
Your Honor. Thank you, Your Honor. May it please the court, I'm Erin Trodden, representing Angel Vasquez Flores, the defendant in this case. In this case, we agree with the government on many points. The government conceded that Mr. Vasquez Flores has met or is excused from meeting the first two requirements of a collateral attack under 8 U.S.C. 1326D regarding exhaustion of administrative remedies and judicial review, because the immigration judge in his removal hearing never advised him of his right to appeal the IJ's decision.
Tell us what you disagree with the government about.
We disagree with the government as to prejudice, Your Honor. The government contends that Mr. Vasquez Flores was not prejudiced, and in fact, he was prejudiced by the immigration judge's errors. The denial of his right to appeal prejudiced him because had he been able to appeal, the outcome of this case would have been different. And he's shown a reasonable probability that he would have been eligible for voluntary departure.
But did he have the means, counsel, did he have the means to depart?
Your Honor, he testified at the hearing that he did have resources available. The beginning of the hearing, the court will have noted that the immigration judge, after going back and forth regarding removability, ordered him to pay a $5,000 bond. And he said, it will have to be less, I don't have any money here. And the immigration judge then said, it's not going to be less. Can you pay for your ticket? No, he didn't even ask him if he could pay. He asked if his girlfriend or someone else could pay for a ticket. And after a long pause, he said no. Later on, he again asked if the bond could be lowered. And the immigration judge said it's not going to be lower. And in fact, now that I've ordered you deported, you don't have a bond at all. So
yes, but does he ever represent that he had the means to depart if the bond was lowered? Does he ever represent that?
He never does. He was never given the opportunity to.
Well,
that condition was never presented to him. He asked for the bond to be lowered, and the immigration judge told him it's not going to be lower. Now, can someone pay for a ticket for you? Now, the way a reasonable person would interpret that would be to mean you'll have to pay $5,000. Now, can you also pay for a ticket? The question of
well, maybe that's the way you interpret it, but I'm not so sure that's necessarily the way that a reasonable person would respond. You might say, look, I can come up with X amount, and I can depart for that reason, on that amount.
Your Honor, I think let me unpack that question because I think there's several issues going on there. He never understood, I don't think, what exactly was being asked or why this was important. And I think this gets to the immigration judge's duty to develop the record as it relates to him. So the immigration judge never explained to him how voluntary departure works, including that he would have a period of time to depart, that he wouldn't have to pay for his ticket within 24 hours or the next week, but that he could have up to 60 days to depart.
Well, all of this would turn on how we would view the term reasonable probability. I know we talked about it in this court in state versus United States versus Wilson, but I don't think we've ever fully articulated what that term means. How do you view, what is your definition in terms of how this court has the decision got us to the definition of what we mean by reasonable probability?
Thank you, Your Honor. Reasonable probability has to mean something less than a certainty, for sure, and it has to mean something less than clear and convincing evidence. So we start with that. The government argued clear and convincing evidence, but that's the standard that he would have had to show in immigration court.
Where's your case law? What cases are you looking at that guide you on that?
So I'm looking particularly at El Shami, which is this court's decision where the court found that the defendant was prejudiced. In El Shami, the court looked at, found that there was a reasonable probability that but for the immigration judge's errors, he would not have been removed. And the court looked at the positive and the negative factors and basically said he has some positive factors. He had, this is a balancing test that the immigration judge would be required to perform. He has some positive factors. He has family in this country. He has a small business. He has been here a long time. But he has some significant negative factors too. He had 2 serious felony convictions. The court looked at that and found that under those circumstances, he had showed a reasonable probability. I think we can deduce from that that this is not a high burden. The cases where courts have found that there wasn't a reasonable probability are cases where very clearly the alien would not have been eligible. And I
Can you speak up a little bit? It seems like your voice is fading. Somewhere in there you faded on us.
I'm so sorry. Can you hear me now?
That's better.
Okay. So I was saying that given El Shami's balancing of those factors and basically saying there are some positive factors, but there are some negative factors as well. This is not a particularly high burden. The counter example would be a case like Lopez Collazo, which is another decision of this court, where the court determined that the defendant had not shown a reasonable probability of success because he was plainly ineligible for the relief he was seeking. Basically, even though he had showed a due process violation, he was still an aggravated felon, and he just plainly, under those circumstances, he had not showed a reasonable probability. Here we have a situation where Mr. Vasquez-Flores, there's no dispute that he qualifies under almost all of the factors for voluntary departure. The only real issue is whether or not he had the means to depart on his own. And his testimony is that he does have means. He does have some funds. Now, the problem is the immigration judge never pursued that. The immigration judge never asked him the obvious follow-up question, what do you have? And the immigration judge also erroneously conditioned his ability to depart voluntarily on his ability to pay this departure bond, which under the matter of MAS decision, which was submitted in the 28J letter, would have been incorrect. The requirement...
I'm sorry, I can't hear you again. I don't know if the microphone isn't closed or what the story is.
I'll lean in as much as I can, Your Honor. I apologize. The matter of MAS decision, which was submitted as the 28J letter, noted that when an alien is granted voluntary departure under safeguards, there's no requirement for a bond to be posted at all. So the immigration judge's decision here to condition the bond on to condition the grant of voluntary departure on posting a departure bond was error. Had he been able to appeal, the BIA would have recognized that and the case would have been remanded. Now, we get to the difference here. He only has to show, as Judge Wynn noted, a reasonable probability of success. So he showed that he's otherwise eligible. He showed that he has funds. Under those circumstances, he shows a reasonable probability of success. The difficulty is...
But I want to be clear, it's not so much me noting it, I'm simply going on a case law from United States versus Wilson, that seems to be some that we've kind of gone with that standard for these 1326D claims. What I was trying to ask you was, in terms of maybe flesh out, what does that term actually mean when we're trying to determine prejudice, and where do we look? I know that case cited a Fifth Circuit case as a basis for it, and that's because to me that's fundamental to know what that term means, or at least to help us to define it, can help us to at least, I think, make a decision in this case one way or the other.
Absolutely, Your Honor. And the Wilson case, I think, and I'm not aware of any cases in the Fourth Circuit that have specifically defined reasonable probability, but I will note that cases in other circuits, and I'm thinking of the Ninth Circuit in particular, have recognized that a reasonable probability requires at least some evidence. And I don't recall which of the Ninth Circuit cases cited in the briefing said this, but it was discussed that at least some evidence was required. So if reasonable probability means some evidence, then we get there. Certainly he has showed some evidence. Reasonable probability, I don't think requires, though, that he show to this court what he would have had to show to the immigration court. Because
But does it require that he make some sort of representation? You keep saying he's established all of these things. And if you have a statute and you have 4 elements to establish, if you establish 3, you haven't established a reasonable probability that you have complied with the statute, have you? No, because the 4th one's missing. That's what we're trying to tease out from you.
Yes, Your Honor. And with respect to that, what we have in the record is his statement to the immigration judge that he had some resources. So he said the bond would have to be less. We don't know, he did not say that he could pay $500 or $1,000 or $2,500. The immigration judge also didn't ask him that. And when he tried to offer that he could pay less, the immigration judge said it's not going to be less. But given that statement twice, that he could pay something, I think he has shown at least that he has the resources. He's shown a reasonable probability that he had the resources to depart voluntarily, and that's all he needs to show. Had the immigration judge developed the record, then the issue would have been different. And the immigration judge's duty to develop the record in this case is I want to be clear, goes to the prejudice aspect of the case for him. But with respect to the questions that the court previously asked in the prior case, our position is that an immigration judge duty to develop the record is one that springs from due process.
Ms. Tridon, let me ask you this question. How long was this hearing?
7.5 minutes, Your Honor.
Okay.
7.5 minute hearing. So if you compare this hearing to the hearing in the prior case, the immigration judge did substantially less in this case than he did in the prior case. He never explained to Mr. Vasquez-Flores what the charges against him were. He never explained to him what relief he was eligible for. He never asked the follow-up questions that would have made it clear in the immigration court what his ability to depart was, separate from the question of his ability to pay the bond. Certainly, due process requires that an alien has a right to a fair hearing, and part of that requirement of a right to a fair hearing is the ability to understand and be able to respond accurately. It's very difficult for an alien to respond, or for anyone unversed in the process to be able to respond to these questions when they're not being given enough information to know what's really being asked. And I think the prime example of that is the question regarding, can your girlfriend or your wife or someone can your girlfriend or anybody else pay for your ticket? And the immigration judge never asks him or never clarifies what the time frame for that is. It would be as if the court were to ask me, can you give me $20? Well, if the question means today, no, I can't. But if the question means tomorrow, probably. It's the time frame matters and the details matter, and these issues were never explained. So this has to be a part of any duty to develop the record, as we've set forth in the briefing. In addition, so for these reasons, Mr. Vasquez-Flores has showed sufficiently that he was prejudiced by the immigration judge's errors in this case. I see that my time is up. Are there any further questions?
Thank you.
Thank you.
Good morning, Jean Hudson for the United States.
Good morning, counsel.
Thank you. Good morning. This court should affirm the district court's decision, which correctly found that Vasquez-Flores could not establish prejudice under the fundamental unfairness test for related to 1326D. The district court got this right, and the decision should be affirmed. In this case, the immigration judge asked Mr. Vasquez Flores, as counsel for has just described, asked Mr. Vasquez Flores if he could pay, or if anyone could pay the $5,000 bond. Vasquez Flores asked if it could be less. The judge said it would not be less. He asked if anyone, his girlfriend or anyone else, could pay for a ticket back to Honduras for him. Vasquez Flores said no. And at the end of the hearing, the immigration judge, in response to Vasquez Flores' statement that he could pay a lower bail, said it was not going to be lower. Vasquez Flores' own statements make clear that he understood exactly what was going on here, that he engaged the IJ with relevant questions about what the bond amount might be, and was, in his own words, unable to pay his way home. He had no means to depart. The IJ developed those facts necessary to make that decision, and the IJ determined that Vasquez Flores could not pay the $5,000 bond, and Vasquez Flores cannot meet his burden applicable to this case.
Yes, let me ask you this. I want to make sure that do you agree that in discretionary decisions like voluntary departure, that a person could be prejudiced by a decision, or do you say that there's no prejudice in a discretionary decision?
The alien has no constitutional interest in the voluntary departure. It's discretionary relief, and therefore our position is that there can be no denial here that rises to a constitutional level, if that is what the court is asking.
No, my question was, I just want to make sure that that you're not taking the position that in discretionary decisions that an alien can never show prejudice. That's not your argument, is it?
No, the alien, however, would have to show, I think, something that rendered the hearing something where he was unable to have a meaningful opportunity to be heard. I think that would be where the alien would have to get, and Mr. Vasquez Flores cannot reach that burden here.
Let me ask you. You mentioned because it's critical in terms of the discussion that went on during that 7.5 minutes. Did at least I don't see it where the defendant was, or the petitioner was ever informed what was the nature of the departure and what the difference would be if he left voluntarily as opposed to involuntarily. In other words, to be able to at least articulate that if the reason I'm asking, can you go back, is because if you do this, then this is what's happened. If you can't, then that happens. If one is standing before a judge and it doesn't seem to make a big difference whether or not you leave voluntarily or involuntarily, then there seems not to be an incentive to do anything like pay your own ticket to go back or say I'm leaving there. Why wouldn't the judge explain that? Well, because he could have had the money for all we know, but he just said, why should I spend money to go back if you're going to send me back? Wouldn't it be fundamental to at least understand the difference between a voluntary and an involuntary departure?
I don't think that Mr. Vasquez Flores can point to any regulation or any statute that requires the immigration judge to make those kinds of or to have that kind of discussion with the alien. And
let me now, maybe not a statute. You're right. It's not a mandated duty by statute, but we're talking about if we're looking at the prejudice prong, we go back to United States versus Wilson here, which talks about reasonable probability, which then that case itself discussed the Fifth Circuit's case. And the Fifth Circuit case, it didn't just discuss it, actually adopted the standard from the Fifth Circuit. The Fifth Circuit's case actually looked at the Strickland standard for there, which your opposing counsel seemed to point us more to the Ninth Circuit direction with plausibility, but it's really the reasonable probability standard that we're looking at, which I think is somewhat higher than plausibility. So how do you? I mean, when you're dealing with that outside the statutory requirement, if you're dealing even from a due process perspective, that you've got someone standing before you and you don't explain to them the difference. Why you are asking them this? Are you able to leave on your own, and do you have enough money? And then he inquires, well, can you reduce it? Now that statement in of itself seems to indicate he's got some money. If he wants it reduced, he probably has some resource, because otherwise you wouldn't ask reduce. And yet there's no inquiry on it from the judge. And then the other thing too is, the judge never tells him that, this bond money would be returned upon his proof of departure. I mean, it's like, I don't know what a bond is. A bond is what? When do you get it? Do you ever get it back? If you get 5,000, if you know you can get 5,000, you might could get someone to give you 5,000 if you knew, all right, when he's on that plane leaving, you get your money back. That's a different, don't you think? There's some need to at least explain that. He took 7.5 minutes. Why did he take a few more minutes and just kind of explain this? Otherwise, we're in these kind of cases, and if we do it the way this judge did, you just go in there and ask the bare bone questions. Says, I'm not obligated to say a word to you on why I'm asking these questions. Okay, send him home.
I'm not sure exactly what the question is, but if I can start with.
Well, let me give you the question. Let me back up, because I did say a lot. So I want to make sure you are sure the question I'm asking. The question I'm asking is, outside of a statutory obligation, which you seem to point to, why is that not a due process obligation to tell a petitioner what you mean by a voluntary departure? That unlike an order of removal, you've got a question here that you ought to explain to him why you're doing this. Why wouldn't you do that? And why is that not critical for the IJ to explain?
Well, as we set forth in our brief, there is no due process right to discretionary relief, and this court has held that there's no due process right to discretionary relief. This court has held that even the erroneous denial of voluntary or of discretionary relief does not trigger due process protections, and therefore there is no due process concern in the circumstances the court has set forth.
So then your answer to Judge Floyd's question is yes. You cannot have discretionary. If you've got discretionary relief, you can't have a constitutional right. That your answer is yes, right? Because you just answered and said no, you didn't mean that. But it seems like to me you're telling me because it's discretionary, therefore you can't have due process rights violated.
Yet there is no due process right triggered here. As we said in our brief, the IJ does not have a constitutional obligation to develop the record in this case, is our position. There is no due process triggered by a duty to develop the record in this case. So if I've said something that was contrary to that before.
Well, I just want to make sure. I think when you're talking Constitution, a discretionary right is different than a right to a fair hearing, which really is fundamental in due process rights. So, I mean, I'm not trying to argue over you, but I want to make sure you explain yourself clearly. No need me to hear you incorrectly and go back and decide a case without giving you a chance to explain what you mean. So, take your time, and if there's something you kind of want to clarify to me, go ahead and do that.
Well, I think maybe I'll start with our position that the immigration judge, regarding any duty to develop the record, the immigration judge has certainly broad statutory and regulatory authority to develop the record. But there is no statute or regulation that the government is aware of that would impose any obligation on the IJ to develop the record in a voluntary removal hearing. to the extent that there is any duty to develop the record where the alien is unrepresented, it is not, in the government's view, a constitutional duty. And in this particular case, to the extent that there is any duty that the court might find, the IJ did fulfill that duty. The judge had before it two questions to answer. One was whether or not Vasquez Flores had the means to depart, and the second was whether the court would, whether he could pay for any bond that the court had the discretion to impose under the regulation governing these proceedings. The court.
So that you know where I'm going, and I accept what you're saying and where you're going with this, but I want to be clear because other circuits have addressed this difference. This difference between a discretionary right is different than a right to a fair hearing where such relief is being explained. In other words, you get you're entitled to a fair hearing where the relief and what you are doing is being explained to you. And here, what I'm honing in on is you've got a judge asking about voluntary departure without any context of explaining what that means to him, other than you just can't leave voluntarily. You don't have the money. Okay, you're gone. And if that's the, because you don't have a duty from your perspective, statutory duty, but I'm not talking about discretionary duty. I'm talking about the fair hearing for what you're entitled to, or to have the relief to be explained. You see where I'm going with that? And if you take it from there.
Well, I think in this context, Mr. Vasquez Flores, in order to prevail, would have to show prejudice, which he can't show here. And I think the crux of this case, in terms of the facts that were developed at the immigration hearing, were that once the judge decided in his discretion to set that $5,000 bond, and once it was clear that Vasquez Flores couldn't pay that bond, it was clear that it was going nowhere. There were two lines of inquiry. The judge did ask about his means to depart.
See, that's the question I'm asking. It is clear at that point he can't pay it, but he doesn't know the context of it. It's a $5,000 bond. It's one thing to get $5,000, give it to someone, and never see it again. It's another thing if you say, well, let me explain to you. $5,000. I don't know where you get it from, but upon the time you leave, the $5,000 is given back. Wouldn't that be? Don't you think? I mean, doesn't that sound like something somebody ought to know? If they want to say, no, I don't have the money, he has some money. We can assume that because he wants a reduced bond. I don't know what amount that was. It could have been almost nothing. It could have been close. Could have been 4,000. I don't know. But he's in this situation. If he understands the criticality of voluntary versus involuntary departure, that question is, wouldn't it be fair to explain that to him? And not explaining it creates a prejudice to him because he can't act on it.
I don't think Vasquez Flores has established prejudice here. It was his burden in this context at the hearing to establish by clear and convincing evidence, and he hasn't done that. Mr. Vasquez Flores had the opportunity. He was given notice and a meaningful opportunity to be heard. The IJ was under no obligation to act as an advocate for Vasquez Flores in this case. And as the district court found, the evidence was not clear and convincing that he had the means to depart. In fact, the majority of the evidence was that he had no means.
What is this 60 days that you can get to fly? Is there such a thing as that in a hearing of this sort? Would he have, when you say, can you fly home, does he have to fly home tomorrow? Or is there a provision to allow him some time period in which to do it?
I believe there is something in the regulation, Your Honor. I'm not finding it right off the bat, but there may be a period of time. I think there's a limit on the period of time that the alien has to depart, but I'm not sure it's in the post-conclusion voluntary departure.
So judge didn't tell him about that. I think that limit is 60 days. Didn't tell him about that. Didn't mention that he could be held in detention during this time. I'm just trying to understand as we do these things, we all want to get through our cases. Just like this argument, we want to move through it, move on. I mean, that's just the nature of what we do. But, it takes a little patience, take a little time to develop it. And I don't know if we want to create a culture with the IJ from a case like this to say, well, you just have to go in and answer this here is going to take you 10 minutes because this guy here, he's not going to be able to answer these questions. He doesn't have the money. He can't pay his own ticket back. Boom, gone. Without explaining anything else. That doesn't sound fair. But I'm sorry, Judge, go ahead, please.
No. I was just going to ask you, you talked about he had notice and an opportunity to be heard. What did the notice say?
Pardon me, what did the notice what? I didn't hear.
Say, was he told in the notice?
I think the notice simply told him to appear before the immigration court on a certain date.
And he didn't know why?
I don't know what he knew, but it was just a standard notice.
Okay, I apologize. He wasn't told why?
I think it certainly said for purposes of a hearing before the immigration judge. I'd have to.
I think what this is what I'm getting at. I think Judge Wynn has made a really pretty persuasive to me case. But the way I read this record of the hearing, it didn't seem to me that he didn't know what a bond was for or what the consequences would be or any of that. So that's why I was wondering, was he told in some notice? And you brought up the notice idea.
Well, the notice says that the Department of Homeland Security has alleged that you are not a citizen or national of the United States. You are a native of Honduras and a citizen of Honduras. You arrived in the United States at or near unknown on an unknown date, and you were not then admitted or paroled after inspection by an immigration officer. And then it says, on the basis of the foregoing, it is charged that you were subject to removal from the United States pursuant to the following provisions of law. And it cites to the 212C provisions. And then it says that he is to appear on a date to be set at a time to be set and so forth. That's at JA 52.
So it doesn't tell him anything about bond or means necessary or any of that. Is that right?
Well, then there's a second page that instructs him that if he chooses, he can be represented, that at the time of the hearing, he should bring any affidavits or other documents which he desires to be considered in connection with his case. And at the hearing, he would be given the opportunity to admit or deny any of the allegations in the notice of to appear, and that you are inadmissible or removable on the charges contained in the notice to appear. And then at the conclusion, he would have a right to appeal an adverse decision by the immigration judge and would be advised by the immigration judge of any relief from removal for which you may appear eligible including the privilege of departure voluntarily.
So he is told at least that there are these two things. He's not told what the consequences are.
Right.
Between departure.
Right. And he's given an opportunity to have counsel. And again, the judge's decision in this context of discretionary relief, voluntary departure, is looking at the regulation governing these proceedings and has the question before him of whether or not Vasquez-Flores has the means to depart, which is required for post-conclusion voluntary departure. And then in the court's discretion, of course, he can set a bond, and the court did that. So in our view, there wasn't anything further left to develop in the record once the court determined that Vasquez-Flores could not meet those two conditions. There was nothing else to determine. Now, whether or not Vasquez-Flores had X amount of dollars or could access certain amount of dollars within a certain period of time might have been something somebody wanted to know under some other circumstance. But here, where the court had established the two things that were relevant under the statute, and were in fact the decisions this IJ had to make, once those facts were developed, there was no need to go any further. So for us, it's Vasquez-Flores' own words, and in fact, in the context where Vasquez Flores clearly understood what was going on in response to Judge Wynn's fairness concern, where he's asked for a lower bail. He understands the court is setting a bail and has asked the judge to consider setting something less. The judge explicitly declined to do so. And again, our view is that this hearing, the issue wasn't going any further then, and Vasquez Flores cannot show that on appeal the result would have been any different.
Let's see, I think your time has expired. Thank you very much for your argument. Do we have any rebuttal?
Yes, Your Honor. Just briefly, first of all, the notice that the government was describing at J52 and 53 is in English. Mr. Vasquez Flores speaks Spanish. There's no indication that that notice was ever actually translated for him into Spanish. At the bottom of it, it says—
How was the hearing conducted? In what language?
It was conducted with an interpreter. It was conducted in English with a Spanish interpreter.
It does seem that he understands why he's there. He may not understand the difference between voluntary departure and being removed, but it does seem to understand. I thought the government's last argument was, look, what you've been trying to say is that there is a reasonable possibility that things would have been different if he come up with if they had probed, if there was some amount of money he could come up with. But the IJ did say, I'm not changing anything. So it looks like maybe that's not reasonable, but it does sort of close the door on a reasonable possibility of a change.
It doesn't close the door on a reasonable possibility of a change on appeal, however. And that's why the due process violation here is he is prejudiced by. He's denied the opportunity to appeal. Had he been able to appeal, he could have, the BIA would have looked at the IJ's decision and would have found numerous problems with it.
Okay, so what is the due process violation?
The due process violation, and the violation that we have argued and that the government has conceded in their response brief, is the denial of his right to appeal. Now, we've been discussing—
That's too broad for me. What denied him his rights to appeal?
The immigration judge never advised—
I mean, he's here, right?
The immigration judge never advised him of his right to appeal. The immigration judge circled the word waived on the written memorandum of his order memorializing the oral decision, but never in the 7.5-minute immigration hearing was he ever advised regarding his right to appeal, asked if he wanted to appeal, or provided any opportunity to file an appeal.
Okay, and so is that the only due process violation?
That's the due process violation we're relying on. Now, we've been discussing the due process violation that comes from the immigration judge's failure to develop the record.
But you don't make that claim. That's not your claim.
That goes to prejudice in this case. And so for our purposes here, although we believe that he has a due process right, but regardless of whether it's a due process right to the development of the record or simply a right under regulation or statute or BIA precedent, the result is that had he been able to appeal, but for the due process violation denying him the right to appeal, the outcome would have been different because the case would have been remanded for further development of the record. The BIA would have looked at this and they would have said, first of all, under matter of MAS, the immigration judge can't condition his grant of voluntary departure on his payment of any bond, much less a $5,000 bond. Second of all, there's no facts supporting why a $5,000 bond. This is an appealable decision. There's no indication on the record of how the immigration judge came up with that amount or whether he evaluated any of the factors that immigration judges typically consider regarding that. And third of all, there's no indication that the immigration judge did what he was required to do under binding BIA precedent, which is to explain to Mr. Vasquez Flores what voluntary departure is and provide him the opportunity to apply for it. I think it's telling in this case, the government refers to how these are, the immigration judge made two separate inquiries, but he made them in a way that put its finger on the scales of the inquiry regarding the voluntary departure. Because properly speaking, he should have asked first, he should have explained to him about voluntary departure, and then said, do you have the means to depart voluntarily? And inquired about how that works and whether he has the means to depart voluntarily, and then he should have inquired about the bond. The departure bond only applies if you're considering someone for voluntary departure. Here he said, you have to pay $5,000. Also, can you depart voluntarily? So the way in which these questions were asked really prejudiced Mr. Vasquez Flores' ability to respond accurately regarding his ability to depart voluntarily. I see my time is up.
Yes, we appreciate your argument. Thank you very much.
Thank you.
We will go directly to our next case, colleagues.
Yes.
Are we all here?
Good morning. I'm Billy Wilkins, and with the court's permission, on behalf of Brad Johnson and Carol Dent, I would like to address the denial of our Rule 50B motion, reliance on advice of counsel, and the Fifth Amendment issue. Beatty Ashmore will address LaTanya Mallory's reliance on advice of counsel, and Nikki Schutt will address the prejudgment allotment issues. The appellants were denied a fair trial. Here are just three of the reasons why. One, if the judge had followed the laws as set out in his charge to the jury, he would have been compelled to grant our motion for judgment as a matter of law. The trial judge charged that to prove an anti-kickback statute violation, the government was required to prove that the appellants knowingly and willfully paid an improper remuneration to induce referrals. The judge then correctly defined improper remuneration as, and I quote, payment for services already paid by another or payment for more than fair market value. There was no evidence of double billing, and there was no evidence that the process and handling fee exceeded fair market value. In addition, the appellants could not have acted willfully. They could not have intended to violate the anti-kickback statute, and they could not have knowingly violated the False Claim Act, because it was not until July 2014, some 6 years later, that the government announced for the first time a new legal interpretation of how it would view the payment of P&H fees. As the DC Circuit held in the Perel case, strict enforcement of the knowledge requirement helps ensure that innocent mistakes made in the absence, as in this case, of binding interpretive guidance are not converted into liability.
So your position, Mr. Wilkins, is that your clients didn't know anything about this until 2014. They had not received any kind of indication or warning that what they were doing was not off track a bit?
Well, I'm not sure the word warning is the same thing as being cautious. And of course, the lawyers are very cautious, as all good lawyers are. But the bottom line—
I don't want to interrupt you, but let's go to that general counsel. And I looked at it and I thought about it. What if you were the counsel in a case like this? That looked like to me was a pretty direct letter. That thing was more than a shot across the bow. That was a shot at the ship directly right there.
I'm sorry.
And the letter from the counsel, from the general counsel, that indicated to them that there was a problem here.
They indicated there may be a problem. He said, what we got to understand is there may be a risk that the government would argue that this is a violation. But the bottom line was, every indication was that this was not a violation of the law until the government came down July 2014 and said, and it even contradicted itself in that order that opinion that I'll get to in just a minute. But the second error that was made by the judge, another error, is he refused to charge the reliance of advice of counsel, which is not only a reversible error, but something goes to what this court should be considering and will consider, I'm sure, when it assesses the lack of the scienta requirement in this case. The third error, the judge unconsciously, improperly allowed the government to ask a non-witness, Kyle Martell, a non-party witness, 62 questions, knowing that he was going to take the fifth 62 different times. And the judge knew this was wrong because he instructed the lawyers prior to trial, I'm going to limit you, and I quote, to your 5 or 6 juiciest questions. Well, the judge did not do that. He allowed 62 questions, and then he turned to the jury twice and said, and an adverse inference may be drawn from Martell taking the fifth. Now, historically, and according to Medicare, the Medicare manual, it's the lab's responsibility to process and handle blood draws, and the cost is paid to the lab by Medicare. And there are several ways to do this. And one way is for a lab to contract with a physician's practice, have the physician's practice agree to do the work, and then reimburse the physician's practice at fair market value. And this is the way a great majority of HDL's competitors handle this job. Nevertheless, before this method was selected, a legal opinion from the healthcare and business attorneys advising them that this was legal was obtained and used to draw up the contract. And the appellants repeatedly sought legal advice during the entire 6 years that they were being paid.
And counsel, one of your arguments is, I think you just told us, that the district court didn't allow you to rely on that advice. Is that correct?
He didn't charge the jury that we could rely on advice of counsel. That's correct.
Okay, well, the district judge did say that when he gave a good faith instruction, this includes all the legal opinions and advice received by or known to the defendants, regardless of the source, to determine whether the defendant acted in good faith. What more do you want?
I want to charge the same that the D.C. Circuit held in the DeFreeze case. And that's the same thing that happened in that case. The judge gave that totality of evidence charge, including you can rely on advice of counsel. The D.C. Circuit says that's not sufficient. Although the charge, and I quote from this case, the defense argued, the government argued, well, they didn't disclose everything to the lawyers. Here's what the court said. Even though that may be the position of the government, the jury was not exposed to one critical piece of the puzzle. Good faith reliance on advice of counsel is a valid defense, and if proved, it is required to be charged. And that's exactly what we have right here. And let me tell you why the judge did not charge advice of counsel. He said, it just doesn't fit. It just doesn't fit. What you did was wrong. You broke the law. Therefore, I'm not going to charge reliance on advice of counsel. Now, that's just not right.
Mr. Wilkins, this is a huge record. You didn't try the case, did you?
No, I did not.
Did you try the case? How long was the trial?
12 days.
Yes, but somebody tells me it's 14 days.
Well, it may, maybe, and like I said, I was not involved in the trial. Mr. Ashmore was. He could probably speak to that.
Okay. Okay. So what is your strongest argument? What do you characterize as your strongest argument here?
The strongest argument, well, I got 3 strongest arguments. The first one, the strongest was, there's no reason in the world for these folks to believe that if they paid a P&H fee at fair market value, that there would be a violation of the anti-kickback statute. Now, until the 2014, July 11, 2014, special fraud alert came out. Here's what I'm reading from this document issued by the governor, OIG, and I quote just a few lines. to make my point. It says OIG has issued a number of guidance documents and advisory opinions, including the 1994 Special Fraud Alert. In these and other documents, we have repeatedly emphasized that paying a physician more than fair market value for his or her services could constitute illegal remuneration under the anti-kickback statute. When a laboratory pays a physician more than fair market value for a physician services, the anti-kickback statute is implicated. Here's the new interpretation. Depending on the intent of the parties, the anti-kickback statute is implicated regardless of whether the payment is at fair market value. Now that's the change right there. And until that time, the defendants had every right to rely upon the fact that fair market value was allowed. Indeed, when this came out, they stopped right then. And its only crime that they committed was not being able to foresee that somewhere in the future, the government was going to change its interpretation and its view and its position on how it was going to view the payment of P&H fees at fair market value. I see my time is about up. Thank you.
Can I ask you one more question before you sit down? This is on my time. So there are three theories of liability here, right?
Yes.
Is it your position that the government had to prevail on all three?
No.
Just one?
Just one. They didn't prevail on any of them.
No, I understand that part. Okay, thank you very much.
Good morning. May it please the court, I'm Beatty Ashmore from Greenville, South Carolina. I did try this case. I represented Tanya Mallory at the trial of the case, and of course I represent her again here this morning. And I do want to build on some of the arguments that Mr. Wilkins just made. Of course, I join and adopt all of his arguments in this case. I want to address in particular the advice of counsel jury charge that Tanya Mallory was entitled to receive and did not get. And Judge Gergel was required to give her that charge, and he didn't based on a mistake of facts and the law. At the jury charge conference, Judge Gergel held at Joint Appendix 4117 that the evidence shows that between January of 2010, when HDL began paying process and handling fees, until April of 2012, when the Ruggio opinion was produced, there was no opinion. So you can't have relied on it. There's no reliance from 2010 until 2012. That is simply not the case. And we introduced a number of documents and live testimony to prove otherwise, to include Defendant's Exhibit 31, found at 5109 in the Joint Appendix. That was an email chain that a competitor posing as a consumer posed this question. You've been contacting physicians and telling them that for every specimen you send your lab, you will pay him $20. How is this not a kickback and a violation of federal law? This is in 2010. So as we demonstrated throughout the course of the trial, that email makes its way up the chain without amendments, deletions, redactions, and it gets its way to Tanya Mallory. And Ms. Mallory does what she always did, and she got the lawyers involved. And she sends this inquiry to her lawyers, who at the time in 2010, that was Dennis Ryan. He was the head of LeClaire Ryan, a 250-member firm. She used only the best lawyers that she could find. She poses this to Mr. Ryan in 2010, along with Patrick Hurd, who is the LeClaire Ryan healthcare expert. And Mr. Ryan sends the email back to Tanya Mallory. We are on solid ground with the OIG advisory opinion. So she gets the advice from her lawyers that she's on solid ground in 2010. Again. So
let me ask the question on this, because I think one thing we want to do is make sure that we cover this fully and understand why Judge Gergel ruled as he did. On the advice of counsel, of course, I think you agree with the evidence, at least the law, that it does require that there's a full disclosure to this counsel. In other words, you can't rely on advice in which you have not told everything. And Judge Gergel essentially says, no, there's not evidence that you told him about this P&H pitch of fees as a lucrative business opportunity. And he says that your clients also received warnings from the lawyers there. And I know Mr. Wilkins characterized those as, well, it's not a big deal warning, but maybe I'm reading something different on that memo that was sent out. But that thing looked like to me, it did more than raise a red flag. It was pretty pointed. But that's essentially what Judge Gergel went on it, is that there wasn't a full disclosure to the evidence. Didn't show that you went in and gave all of the facts, and therefore got this advice to say, okay, to go with it. So because it requires good faith reliance on it.
I agree with that, Your Honor, of course. And that's at Joint Appendix 4179, where Judge Gergel says there is no evidence of full disclosure, and I could not more strongly disagree with that. To the contrary, Tanya Mallory, the evidence was uncontroverted. She shared everything with her lawyers, to include Ropes and Gray at the end of this case, and she was paying them $1 million a month. That's the level of interaction she had with her lawyers. And there's no evidence in the record whatsoever, no evidence to indicate that she did withhold something from her lawyers. We had hundreds.
But before you leave, and I get your point on that, even if that's true, why is this instruction, Judge Gergel's instruction, not sufficient here? I mean, he does tell them that that they can rely upon the good faith, and that you could rely upon legal opinions and advice received by, regardless of the source of it. I mean, that's part of the instruction that he does give. So why is that not substantially covering this instruction that you sought to get?
It does not go far enough. Good faith is certainly a strong defense, but the jury charge that we requested would absolve Tanya Mallory of any liability. Had we gotten that jury charge, the jury would have returned a defense verdict. Bear in mind, we won 90% of this trial, is what I like to say. The government asked for $186 million in the opening, and the jury gave them $16 million. And so it simply does not go far enough. We needed that charge to be presented to the jury. And had that been done, Tanya Mallory would have received a defense verdict.
Mr. Ashmore, your time has expired unless my colleagues have any questions. I have one other question. None of the defendants claim a safe harbor, do they?
I don't believe so, Your Honor.
Okay. Does anybody else on the court have a question?
No.
Mm-hmm. Okay, thank you. This is always a problem when you divide argument.
May it please the court, Your Honor. My name is Necki Shutt, along with my colleague Sarah Cox, who you're going to hear from next. We represent non-parties in interest. Specifically, one of the defendants in the case Judge Wilkins just talked about is Cal Dent. We represent the family of Cal Dent. I hope Judge Floyd recognizes me from 3 years ago. 3 years ago, we were up before this court representing Mrs. Dent and two companies of hers before Judge Gregory, Judge Floyd, and Judge Duncan, asking this court to dissolve pre-judgment remedies. What the court held then was that it was interlocutory, so we are back again now that there has been a final judgment, and asking this court again to dissolve those as overreaching and clear error. So it's fair to say that Mr. Dent's family was under siege, Your Honors, within 6 months of this case being unsealed. Under the Federal Debt Collections Procedures Act, the government asked for pre-judgment remedies and did not just ask them against Mr. Dent, against a party, but also asked them against his wife and companies, and ultimately against his parents, her parents, 10-year-old son, 2 other children. And so as to Mrs. Dent, there is clear error in her companies, Lakeland Pines LLC and Trinity Island LLC, clear error by the court and overreaching by the government in having those writs of attachments attached to her property without following subchapter D of the Federal Debt Collections Procedures Act. Under subsection D, the government must bring an action and proceeding that was not brought, and therefore it is clear error. And I'm sorry, my time has already expired. I will answer any questions that the panel has.
I don't think we have any. Thank you very much.
Thank you.
We'll hear from the government.
May it please the court, Benjamin Schultz on behalf of the United States. Following a lengthy jury trial, the jury returned a verdict finding that defendants Dent, Johnson, and Mallory were liable for numerous violations of the False Claims Act. The evidence showed that that could be sustained, among other reasons, because the defendants engaged in an illegal scheme to pay commissions to independent contractors.
So your other side says it's not illegal because it's below the fair market value.
So to be clear, Your Honor, that argument is about the P&H fees, and I'd be happy to walk the court through the numerous pieces of evidence from which the jury concluded that these were substantially above fair market value. But that was
you don't need a lot. You just need to be able to show some evidence that we're be able to support it. So you don't need to spend a lot of time. If you think it's there, then tell us what it is.
Absolutely. Let me walk the court through all of this evidence. And you can find a lot of this on page 39 of the government's brief. So first,
can I ask you, just before you begin, can you tell me, is there sufficient evidence in this record so that we could affirm on just one of your theories?
Yes, any of these.
Sorry, go ahead.
Oh, I'm sorry, Your Honor. Yes, any of these theories would be sufficient. So if it's the commission theory, that would be entirely sufficient to sustain the verdict. The P&H theory or the medical necessity, any one of these theories would be sufficient to sustain the verdict.
And secondly, what do you believe is your strongest theory?
I think there's the commission theory and the P&H theory have different things. The commission theory is a little bit cleaner because I think the defendants spend a lot of time trying to claim that they had counsel's advice with regard to P&H fees. There's all sorts of problems with that, and I'd be happy to walk the court through that. But with the commission theory, they never introduce any evidence that any lawyer specifically told them that this was not a violation of the anti-kickback statute. There is significant evidence that lawyers warned them the other way, that the commission scheme was a big problem. And of course, that's the clear language of the anti-kickback statute, which says that you can't pay remuneration to someone for, among other reasons, to induce them to either encourage, to recommend that someone have a federally funded health service, or to arrange that someone have a federally funded health service. And that's exactly what these independent contractor salespeople did. And I'd be happy to walk through the evidence that they were specifically warned by that, or I could go answer Judge Wynn's question about fair market
Judge
value.
Wynn's question.
Certainly.
I want you to stay right where you are. Judge Motz is asking you to look at these claims. You don't have to do all of them. What is your ringer? Which is the one if you had to hang your hat on? Because that's you do have multiple ways to do it, but if there is one that is very clear, we can focus in on that more so. Or you may want to say, well, they all are just equal, as Mr. Wilkins indicated.
Sure. Well, I think the court might be able to write a little bit of a shorter opinion if it goes on the commission theory. So I'd be happy to walk the court through that one if you'd like. And just starting with the evidence about how they were warned away against the commissions, I'll start at Joint Appendix, pages 25, 69 to 70. This was the testimony of Nicholas Pace. He was an attorney who worked for HDL. He was a senior executive. He oversaw their compliance efforts. And then I'll just read the testimony. Question, did you see an issue with paying commissions to the third party, Blue Wave? Answer, I did. Again, if you go back to the anti-kickback statute, there's a prohibition against that. There's safe harbors for that, and this was not structured to comply with that. Question, and did you talk about that concern in board meetings? Answer, we did. And it's also set forth in Derek's memo, referring to the general counsel's memo. And if you go to that memo that Your Honor was referencing with regard to that language, that memo, in addition to identifying the problem with the P&H fees, also identified problems with the commissions. Then there's additional stuff. There's the evidence that a contractor's attorney, this is Emily Barron, she was a Blue Wave contractor, her attorney notified Dent and Johnson's attorney that this was illegal. You couldn't pay commissions to an independent contractor salesperson. It violated the anti-kickback statute. There's evidence, and we cite this in our brief, that these concerns were relayed both to Dent and Johnson and Mallory as well. And instead of trying to get an attorney's advice, trying to get to the bottom of it, they abruptly terminated their relationship with Emily Barron. So she's asking questions. She's telling us this is illegal. We're not going to do business with her anymore. That's not good faith attempts to comply with the law. That's trying to brush this under the rug. In addition, we introduced evidence that Dent and Johnson hired an attorney, and that attorney sent them an 11th Circuit opinion that upheld a criminal conviction for paying independent contractor salespeople commissions. The 11th Circuit opinion was important, one, because it was their attorney who said, hey, you should take a look at this. And two, Blue Wave was actually an Alabama company. Johnson was located in Alabama. So this created binding circuit precedent in Blue Wave's home state. And the jury at the least could have concluded that Dent and Johnson were aware of that opinion. So we think there's plenty of evidence on the commission.
Under the commission theory, is the kickback that was just the volume-based commission paid to Blue Wave?
So no, there's two different theories. First, there was the fact that Blue Wave was hired as HDL and Singulex's independent contractor, and the contract with Blue Wave paid Blue Wave a volume-based commissions. Then also the evidence was that Blue Wave turned around and the salespeople that it hired were also independent contractors, and they were paid volume-based commissions. So both of those are illegal. Now, granted, Mallory didn't go out and hire the independent contractor salespeople, but Mallory did hire Blue Wave as the independent contractor. And of course, Mallory could be liable under the conspiracy theory for Blue Wave's additional violation of going out.
Well, if HDL hadn't been paying the P&H fees, would the fee structure between Blue Wave and HDL alone be enough to make them liable?
So even if P&H fees were never part of the case, the commission structure alone was illegal. And that was what, actually, in fact, HHS had warned about publicly in the Federal Register. That's the clear text of the anti-kickback statute, which creates that exception for employees, but there's no statutory exception for independent contractors. And frankly, I think this case really illustrates the danger of paying commissions to independent contractors because you had all of these improper practices. Indeed, Dent and Johnson, I'm sorry.
No, I was just going to ask you, so if the defendants were paying the fair market value with the P&H fees, would there still have been a violation of the AKS?
Absolutely, because they were paying volume-based commissions to independent contractor salespeople, and that's just
even
clear.
If it's a fair market value.
Well, so the P&H fees, even if they were fair market value, and I still would like to walk through, Judge Wynn, the lots of evidence that I have about that. But yes, the statutory text is really clear. It says if you pay any remuneration for a prohibited purpose, some of the prohibited purposes are to induce a person to arrange for the provision of federally funded healthcare services or to recommend the purchasing of federally funded healthcare purchases. And that's what salespeople do. And indeed, one contractor even testified that he was paid commissions to literally arrange for doctors to order HDL and Singulex tests. And of course, as well, these salespeople recommended to doctors that they order HDL and Singulex tests, and they were paid these commissions to do so. Now, as to the P&H evidence, because I know Judge Wynn asked about it, let me just go through some of the evidence, and there's more. First, I'll start with Joint Appendix pages 2155 to 56. And 2160 to 61. These are from the testimony of
you really don't have to read to us this. You just point it to us in the record. I mean, it's almost like an exercise that's interesting, but we've read this and read what's in the record. If you point to us in the record as evidence here, we read it. We got it.
Absolutely. So if the court doesn't want the joint appendix, I don't have to give them. What I was going to bring up was the testimony, among others, of Dr. Michael Mays. He testified that his practice's blood processing costs were substantially less than what the P&H fees were. And he described how his practice would calculate how much they got in fees each month, deduct all their expenses, then distribute the remainder to all the partners as profit. You even had one of the defense witnesses, Dr. Alem. He acknowledged that his practice profited from P&H fees. Then you've got the marketing emails. There was, for example, an email that was sent from one Blue Wave salesperson to a doctor, and he said he sent this at defendant Dent's request. It attached a spreadsheet, and it was a comparison, and it showed how if you got P&H fees, it would significantly exceed the cost of hiring a full-time phlebotomist, which is the alternative. There's another email that's really probative here. That's an email, and again, I provide the record set if you want. That's from Mallory to Dent and other Blue Wave salespeople. Talks about how a doctor really wants to use HDL, and he would like HDL to provide a full-time phlebotomist. And Mallory says, well, why don't you show him why he's better off getting P&H fees instead? And I think that's a really probative email because it, one, shows that this wasn't just about, a good faith attempt to get the doctors to have the blood. Here's an email in which the doctor is saying, hey, I'm ready to use you. Just give me a phlebotomist and we're all set. And Mallory says, no, let's show you why you really want the P&H fees. And the jury could easily conclude from that, one, this was above fair market value, and two, that the point of these fees was an inducement. It was to get the doctors to order more tests to get more money. There's also evidence from some of the contractors who testified. You, for example, have the testimony of Boomer Cornwell, who was one of these contractors. He talks about how he sent a marketing email advertising the P&H fees as lucrative. And I haven't even gotten into the Medicare evidence. And of course, there was tons of evidence that Medicare already pays for process and handling services, that these are part of the Medicare bundled payment. And there was testimony that the Medicare bundled payment is fair market value for the entire bundle of services. But then the defendants were paying these people on top of Medicare. That's important as well, because there was evidence that not only was Medicare already paying for this, but the defendants were out there, their salespeople were selling this to doctors as you can take P&H fees on top of Medicare reimbursement. It was also the case that Medicare reimbursement was always more than the P&H fees. So of course the doctors were not going to forego Medicare reimbursement in order to get P&H fees. And the defendants acknowledged that. The defendant Dent even testified that he expected the doctors to bill for Medicare visits. I could beat this to death if Your Honor wants more, but we think there was more than enough evidence that the jury could reasonably conclude that these P&H fees exceeded fair market value.
How do you explain the fact that you asked for 186 million and you got 16?
Yeah, so there are a lot of different ways the jury could come up with that. One possibility is that the jury concluded that maybe initially when the defendants started out in this scheme, they had a good faith basis for thinking what they were doing was right. But as the attorney warnings mounted and came in, at a certain point, the jury might have concluded, all right, now you've gotten so many attorney warnings that you no longer have the good faith. You are willfully violating the anti-kickback statute. And from that point forward, we're going to find you liable.
I don't have the verdict in front of me. So what was it? Were there any questions that were asked of the jurors?
It was a general verdict. The jurors were asked to, as to each defendant, say whether that defendant was liable or not liable.
And they acquitted Blue Wave,
yeah, the LLC, right. So the jury was asked to find as to each defendant whether that defendant was liable, and then what were the amount of claims attributable to that defendant, and what was the damages to that defendant.
So can I ask you one other question? In its reply brief, the defendants say that the government could not bring this case today. Is that correct?
It's absolutely not correct. They're relying on a memorandum from a former Associate Attorney General. First of all, that memorandum has been superseded by a more recent version. But the more important point is that that memorandum makes clear that one thing you can rely on agency guidance for is scienter, and that is so I don't even understand their objection. But the more important point here is that the agency guidance is kind of a sideshow in this case. The statutory language is clear. We're relying on the statute. The statute says you can't pay remuneration to someone for a prohibited purpose. It lists those prohibited purposes, and there's no serious dispute that these are those prohibited purposes. So the court really need go no farther than the statute itself. That's the source of liability, and that to the extent there's agency guidance, it just reinforces that they had the guilty mind, that they had the scienter. I'd be happy to go over this more. I do want to talk a little bit about the advice of counsel defense because there's some important parts missing from the defendant's presentation before this court. And that's that, among other things, in order for this court to reverse on a jury instruction issue, the defendants have to show that their proposed instruction was correct and that failure to give it was prejudicial. And they fail on that dimension in about 3 or 4 different ways. And I would urge the court to go take a look at pages 1663 to 64 of the joint appendix, which is their proposed instructions on advice of counsel. The first thing that jumps out about that is they wanted the district court to charge it as an affirmative defense on which they bore the burden. When the district court refused to do that, that made it easier for them to establish advice of counsel, not harder. So especially in light of the fact that the court did charge on good faith, he did say that the jury should consider the advice that is known to the defendants from attorneys, and they didn't bear the burden, even though they had wanted to bear the burden on this. It's hard to see how there was any prejudicial error here. The next thing that jumps out about their advice of counsel defense is that they wanted to charge it as a complete defense. That's legally wrong because if you got advice of counsel as to one issue on which you've faced liability, at best it would give you a defense as to that issue, but it wouldn't give you a defense as to the other issue. So for example, even if the jury believed that they relied on counsel's advice to the P&H fee scheme, it wouldn't be a complete defense to liability. They would still face liability on the commission scheme or on the lack of medical necessity. Another problem is that if you look at their advice of counsel instruction, there's a really important word missing. They wanted the district court to charge that if any defendant faithfully follows the attorney advice, then the defendant is not liable. That's missing an important qualifier. You have to not just faithfully follow the attorney's advice, you have to follow it in good faith. And if the jury concluded the defendants got an opinion that they liked, and then 10 other attorneys told them why that opinion wasn't worth the paper it was written on, the fact that they followed that advice in bad faith would surely not insulate them for liability. And indeed, I'm sorry.
No, I was just going to ask you, was there discussion about the instructions with the district judge?
There was, the district, I think the district court talked about how he thought that there hadn't been a complete disclosure of all the relevant facts. And I'm happy to explain why that was right. But I don't think the court even needs to get there because there are so many problems with the instruction that they proposed. And their request to charge this as an affirmative defense surely was not prejudicial error as to them.
So I guess what I'm asking is often in simpler cases than this, to be sure, we have a whole hearing where there are instructions offered by one side and then instructions offered by the other, and the judge chooses between them and people give their objections. Was there that kind of thing?
There was a charge conference, Your Honor. I think where maybe the confusion is coming from is that the parties gave written proposed instructions and they were numbered. And then this was discussed over an extensive charge conference. And at the end of the charge conference, you can see that from the transcript that the district court was clearly looking at the written instructions, and they were written proposed instruction. They were numbered instructions. And the judge goes down as to each one he's not giving. He explains, all right, as to number 20, here's why I'm not doing it. Number 21, here's my problem. Number 22, et cetera. So I think that discussion in the transcript makes a little bit more sense if you also have the proposed written instructions in front of you.
And they are in the record, right?
Absolutely. And this Joint Appendix 1663 and 64 are the defendant's proposed instructions on advice of counsel.
Okay.
And I want to add one other point on that, which is that their complete defense language was also legally erroneous because, as this court recognized in the Drakeford opinion, even if you get a counsel's advice, and maybe it might be reasonable to rely on it for a period of time, if a later attorney later tells you all the reasons why that previous attorney's advice can't be relied upon anymore, if you continue to rely on that first attorney's advice who told you what you want to hear, you might no longer be legitimately relying on the advice of counsel, and the defendant's proposed instruction again would have just given you this complete defense language. So as soon as they got one opinion, then they could have closed their ears off to everybody else who told them that what they were doing was wrong.
Let me ask you, was it the government's duty to show that the defendants didn't fully disclose everything to their attorneys?
So I think in order to whether or not they get the instruction, The district court thought that there hadn't been a complete disclosure at the relevant time. And I think it's important to understand this court's case law does talk about how you have to get the attorney's advice before you engage in the illegal activity. The only thing that they have pointed to in their brief that predates the whole scheme was this 2009 email that Mallory sent and gets forwarded to attorney Patrick Hurd. Patrick Hurd's email, which the court can see, it's in the record, it's a qualified opinion. He says, here's my initial take. I want to think about it some more. I want to go read some stuff. And then there's no evidence in the record that goes beyond that shows that he actually blessed this. And in fact, Patrick Hurd is interesting for another reason, because he shows up again later in an exhibit. You can find this fascinating email chain at Joint Appendix 5058, which is when Mallory drafts her position statement on P&H. Her position statement concludes by saying, this doesn't violate the anti-kickback statute and the False Claims Act. Hurd responds and he says, I've made some corrections. He deletes that statement where she said it doesn't violate the anti-kickback statute and the False Claims Act. He deletes it, and you can see that in the red line. And instead he says, well, it complies with some of the requirements of the safe harbor. And that's all that he was willing to say. So I think it's particularly hard for them to say that Patrick Hurd somehow blessed this and that they relied on counsel's advice from the very beginning. I'd be happy to address any other questions. I know there's a lot of issues in the case, but otherwise we would ask this court to affirm.
Thank you very much. We appreciate your argument. Mr. Wilkin?
We sent to the court a day or two ago a recent case in Reynolds versus Furman Capital. And there the then law firm was sued for malpractice because it didn't tell their client it was claimed that they were paying illegally. The court said no, just because they charged it, told you that it was a risk. Not mean they had to tell you.
Mr. Wilkins, we can hardly hear you. At least I can. Maybe you're not near the microphone. I don't know.
In any event, can you hear me now? Anyway, the court granted summary judgment in favor of the law firm because they said the law is unclear as to whether the payment of P&H is legal or illegal until the special fraud alert was issued by the Department of Justice. Now, the contract we're talking about, the P&H contract, was drawn up by lawyers before they even started doing business. That is how we're going to pay $3, $17. The lawyer, that was fully disclosed to the lawyers, and it was drawn up by the lawyers, and it was never modified, strictly adhered to by the appellants during the entire time they were in business. In July, the special fraud alert was issued, but 6 months before that, James Levinas, the Department of Justice, who was always back and forth with these lawyers all this time, interaction with the Department of Justice, making sure everything was done right. He said in writing, I know I have not informed you of the government's position whether or not the payment of P&H constitutes an anti-kickback violation. And then, of course, comes the special fraud alert, and the government says, well, this was issued because it's just like many of the others we issue. When the area is vague, and I'm quoting, and the area is vague and not spoken, that needs to be clarified, we will issue the special fraud alert. And and it was not until that time that there was really any definitive statement by anybody that what you're doing is illegal. Now, Your Honor, you mentioned the Klung memo. One, that was never given to Johnson and Dent. And number two, contrary to what the government says, he did not say this is illegal, what you're doing. I quote from what he said in his memorandum to that he wrote. He says there's a high risk that OIG argue that the P&H does not meet all the requirements of an AKA safe harbor. Now that's a far cry from saying something is illegal. Certainly there's a risk in about every major business decision anybody makes. The question is whether or not you cross the line and whether or not it becomes illegal. Now, let me mention the advice of counsel just a minute. That is an affirmative defense, contrary to what the government says, and we were entitled to an affirmative defense charge to the jury. Here's what the DeFreeze case, DC, a leading case in this this area, this issue. Even though the government produced a laundry list of supposedly facts allegedly not disclosed, the district court was required to give the reliance of advice of counsel charge if there's any foundation in the evidence sufficient to bring this issue into the case, even if the evidence is weak, even if it's inconsistent, even if it's of doubtful credibility. Well, in our case, the evidence of reliance advice on counsel was not weak. The contract was drawn up with the lawyers doing the drafting, but it's a P&H fee contract. And it was not inconsistent, and it was not of doubtful credibility. But even if it had been, we were entitled to a jury charge on advice of counsel. Let me mention taking the Martell was a non-party. He was called by the government. A unit man thought this he was going to take the field. They were allowed to ask him 62 questions. Out of the blue, the judge, halfway through the questions being asked, he said, I believe there's adequate input, but he's a co-conspirator. Therefore, I'm going to charge a jury an adverse interest. And let me kind of give you an idea of what this meant as far as the harm to the appellants here. Here's what happened. During the question 61, the government approaches the witness, shows them a piece of paper that's an email. The question is this email from Bakran Siani was sent to Scott Tramboni? He says, Martell says, I take the fifth. The government then turns to the jury and publishes this email. You see here, Mr. Tramboni writes, please tell me how this is not a kickback. And then the lawyer turns to the judge and says, we offer this in evidence, Your Honor. Well, of course, the judge sustained the objection, but it's too late. The damage had been done. It was published to the jury. Immediately thereafter, Martell is excused. The judge turns to the jury and he says, you can draw an adverse interest from the fact that he's taken the fifth. So, highly prejudicial. And even if that was not the case, asking 62 questions, 62 I take the fifth, is highly prejudicial, as other courts have so held.
Mr. Wilkins, I think your time has expired unless my colleagues have some further questions.
I said I've got another minute, Your Honor.
No, I think that means you're over a minute. Thank you very much. Counsel, we're ready to hear from you.
Your Honor. May it please the court, my name is Sarah Cox. I'm here on behalf of Hunter Dent, Haley Dent, and the minor child LD in this appeal. Hunter is a 25-year-old former Army cavalry scout who's now a truck driver. Haley is a 24-year-old cosmetologist, and the minor child LD is a 10-year-old boy. The government seized my client's savings accounts pursuant to a writ of execution on November 29th, 2018. Even though the Federal Debt Collection Procedure Act, under which these writs were issued, requires notice to be given, to be served on any person whom the government, after diligent inquiry, has determined has an interest in the accounts, and even though my client's social security numbers were on those accounts, and Hunter and Haley were both over the age of 21, none of them were given notice that these specific accounts would be levied by the government. The way that the government reached these accounts...
Let me ask you about the accounts so we understand. These are accounts that were created under this Uniform Gift to Minors Act? At least,
yeah. Yes.
Right? So we have the initial question of the donative intent in terms of creating those accounts. But then Mr. Dent apparently did some things with the account or failed to take some actions that are required by that act when the children become majority age. And so that sort of creates an issue here of when you don't do something to the account. And of course, there was some moving around of money too. I mean, if it was just money that you had in a minor's account, I think there was the youngest one, that account is not at issue here. Is that right?
The minor's LD's account was ordered to be released from the court registry, but that has not happened yet.
But my question is, it's not an issue here.
No, the donative intent.
And it sort of makes sense because that is under the Uniform Gift of Minors Act. Is the donative intent, I guess, is presumptive, and it's just there. I mean, it doesn't sound like there's any basis. But the problem with the two older children's account, at least one of them, actually the money was taken out and put in the other one, other account. Is that right?
Yes.
And so you got this control over this account that seems to be, well, you know, yeah, it's yours, but when it gets to a certain age, you're not under this act anymore in terms of the gift. So if you take it out and use it, then it seems like, I'm not sure there's a donative intent that's been established. So isn't that kind of the issue here as to the donative intent in terms of establishing those two accounts, given the disposition of what's going on with them?
Yes, sir. So when we look at donative intent, we look at the moment that the corpus of those accounts was placed in the children's names, which happened in February 2011, when the children were still all minors. So Hunter was 16, Haley was 14, and LD was under a year old. So the donative intent is established at that time. And at that point, under the Gifts to Minors Act, when the money is put, or when any property is given, title to that money, legal title and equitable title, is indefeasibly vested in the child. Legal title is indefeasibly vested, and title is irrevocable under that act at the moment of the gift, which is part of the purpose of the UGMA, to allow parents and other adults to give gifts to children that
who has equitable title.
The children also have equitable title because the corpus of those accounts, while they are minors, the corpus of those accounts can only be expended for their benefit. And there is case law in bankruptcy court. It seems that this is the only time it really comes up, but there is case law in some bankruptcy court decisions that says that legal and equitable title is held in the same. And any time that those two legal fictions exist in the same person, those fictions merge and full ownership of the account is in that person. The donor and the custodian of the account.
Let me understand your simple argument, not simple argument, but the argument simply explained, I didn't mean it in that way, is that once you create a gift that's given under the Uniform Act, the donative intent is established there. It is no longer any question of who this belongs to, and that's the end of the case.
I wish it was, sir, but I think
no. But I mean, if that's all it is, it's their money. It's their money. It's the children's money, legally and equitably, under your theory, and therefore anything that a trustee or those who's the guardian of this money would do to it has no effect. So one cannot put money into this account and then be required by law to transfer it out at a certain age, but fail to do so. Because once you take it out, once it hits that legal age, you're out of the Uniform Minors Act protections. And so then they could just take it and just use it.
Under the UGMA, the terms of the UGMA accounts here, the children, we're going to refer to them as children, even though both of them are old.
I understand that. That's a good way to refer to them.
Okay. The children, once they reach the age of 21, have full authority to remove that money if they would like. It's their account.
So they could sue Mr. Dent for their money.
If he had taken it out of their accounts, they could. They don't have to. If the money was in their accounts, they could, under the terms of the accounts, go into the bank and remove the money themselves. It's under their social security numbers, their birthdays. Wells Fargo's policies say that the children have full access to that money once they turn 21. Dent is not required.
Why didn't they? At 21, why don't you just go get your own money?
Well, I think that there is no evidence in the record as to their intent for why they didn't do that. But in this case, it was reasonable to assume that by the time for example, Haley turned 21. She was 22 and a half when the government took the money out of her savings account. Hunter, I believe, was deployed at the age of 21. So his reason, it's speculative, but his reason for leaving the money in could have been that he is deployed. But again, there was no reason for them to remove the money until the government took it out of the accounts.
Ms. Cox, go ahead.
I was just going to ask if we have jurisdiction here.
Yes.
Well, what's the final order that you're appealing?
The final order that we are appealing is it's a bit of a procedural oddity, but the district court issued an order on, after requesting motions for summary judgment on the question if Dent had substantial non-exempt interest, and the district court ordered that Dent had a substantial non-exempt interest in the account.
Yes.
And so we are appealing that order.
Well, there are a whole bunch of claims in this case, and the district court issued a, what do you call it, 54B ruling in order to get us the issues in the prior appeal. It didn't issue any 54B ruling here, and we still have all the common law claims in the case. So I don't understand how we have a final judgment.
I'll be happy to explain that.
Sure.
Absolutely. If the government had given the Dent children the required statutory notice that their accounts were going to be levied, which it did not do, the government would have, under the Fair Debt Collection Procedures Act, the Federal Debt Collection Procedures Act, the government would have given notice to serve notice on the children. The children would have had an opportunity to file a motion to quash the writ of execution as to their property. And then if that was denied, if that motion to quash was denied, the government, then the Dent children have standing to appeal to it's an appealable, a final appealable decision. So in this case, the fact that it was summary judgment is it's a procedural oddity because we were never given the chance to move to quash the writ of execution before it was issued. And there's no procedure.
This doesn't go to the merits. It goes to the question of whether we have a final order in front of us over which we have jurisdiction.
Yes. So in effect, this is a denial, even though it is on paper a motion for summary judgment. In effect, this is a denial of the Dent children's motion to quash the writ of execution, which is a final appealable judgment. The only reason it isn't is because of the procedural oddities that were created by the government.
Okay, you understand this is a big sprawling case. God knows you understand that, right? And the district court ruled on those statutory claims that we talked about in the prior argument. You heard that, right?
Yes.
There are a whole bunch of common law claims that the district court never ruled on. They're the meat of this case. They from those claims, your claims grow. Okay? The district court granted a 54B motion for us to consider all the things that we considered in the first appeal. It didn't grant a 54B motion with respect to anything else, including what you were trying to raise in front of us.
Under the law, I do not believe that that the district court needed to grant a 54B motion for this. Because
I understand your argument now.
Yes,
you don't think because it's necessary. We somehow get a final judgment because of what?
Because it, in effect, this is a denial of a motion to quash a writ of execution. Okay. We were not given the opportunity to actually file a motion to quash a writ of execution, but procedurally, as soon as the Dent children found out that their accounts had been levied, we objected, and that objection was taken by the district court in essence as a motion to quash a writ of execution. It is not. Well,
Ms. Cox,
yes.
What effect does the fact that you filed a motion to reconsider the district court's ruling? It was dismissed without prejudice. Does that affect our jurisdiction and finality?
I do not think so. I do not believe that it does. The district court held firmly that there's a substantial non-exempt interest, and the fact that we had filed the appeal out of an abundance of caution to preserve the deadline, and we had filed the motion for an expedited hearing on that matter, but it was never heard by Judge Gergel by the time we had to file our appeal.
Well, do we on that your purported motion to quash, which apparently ended up like a summary judgment motion, is the standard review abuse of discretion?
On a motion to quash?
Yes.
No, it's because it's on the merits, it's de novo. But even if it was abuse of discretion, the court in this case absolutely did abuse his discretion when it came to the facts. The district court discounted the fact Dent's entire affidavit in support of his donated intent. It discounted the other evidence that was presented in favor of the government's evidence, which was simply that the accounts existed. Dent's name was still signatory on those accounts, even though under the South Carolina statute, which determines property rights in this case, these children indefeasibly have this money. And going to
so let me ask you about this. This is a summary judgment situation, and I'm wondering if there's not at least an issue of fact, and maybe that's where you're going. You would like it to be resolved in your favor, but these accounts that you indicate as though per se the donative intent is established once you set up the account. The problem is under the South Carolina Uniform Gift of Minors Act, Mr. Dent is actually the custodial manager of the account, which means that when the children reach the age of 21, he then turns the money over. If he does not turn the money over, then it sort of indicates, well, you never intended to give it to him in the first instance. And that's the problem, the conundrum, at least the evidence that's presented on the other side. There is evidence, it appears to me, as though he did have the donative intent, but I'm not sure it rises to a level of saying it's undisputed. Because you do have this instance, and even from your perspective, it's not undisputed because he does take the money out of Mr. Dent's, out of the Hunter Dent's account, and he does put it in another account. He takes it out. Hunter can't take it out, obviously. Because if he could, he would, when he reached the 21, when Mr. Dent thought it was irresponsible, he says, no, you can forget it. I'm 21, I can get my own money. It doesn't work that way. He's the custodial manager of the account, and then he has a duty to do something with the money once you hit a certain age. He didn't do it. He didn't do it either one. And of course, his reason is, I've got litigation going on. And because I've got litigation going on, I don't want it to look like I'm doing something fraudulent. So how does that square with this? At the best case, I'm looking at, from your perspective, there may be an issue of fact here. I don't know what's going on, an issue of fact, but I don't see how that becomes undisputedly in your favor.
Yes, sir. So I'm over time, but I'd like to answer.
You can answer the question. Yes.
Thank you. The money that was taken out of Hunter's account and put into Haley's account was during the time that Dent was legally still the custodian of the property. The property is the issue here, not the account itself. That depositing the property in a UGMA account establishes that donative intent, and there's a presumption of donative intent. When he moved that money, he had every intention of moving it back at the time or at 21 that Hunter would have access to the money. And
that's the issue. He never did. He never did move it back. He didn't give either one of the money.
At that time, he had been sued. Dent had been sued for $50 million in federal court. And that was in around 2015 or so. I'm talking about when they actually did reach 21. He didn't give it to him. Right. Yes, sir. In August 2015 was when the complaint was filed and unsealed against Mr. Dent. And Hunter did not turn 21 until December of that year. So he was at that point, and as Mr. Dent testified in his affidavit, he was concerned that moving that money would risk the government seizing the money from his children. And that is established in Dent's affidavit. And there's no other evidence that would have been the case. Now, again, he didn't move the money back. And at that point, but that does not mean that it's Dent's money. And
all right, I got your answer. Thank you.
Thank you.
Thank you very much. From the government?
Yeah, Your Honors, and may it please the court, Jack Starcher on behalf of the United States. Appellants asked this court to review a decision of the district court that by its own terms only sets the terms of a supersedious bond and clarifies the terms of a supersedious bond pending appeal. As this court noted, there is still work to be done in this case, and therefore this is not a final judgment that this court has jurisdiction over. In fact, in an earlier appeal in this very litigation, that's the Lutz, United States versus Lutz appeal, this court looked at similar sorts of, in that case it was prejudgment attachments. Here we have a supersedious bond securing an appeal. But in that case, this court looked
So we are here on summary judgment, and the question is, when we review this, I take it we review it in a light most favorable to the children. And while there does appear to be evidence, he didn't give the money back, that there was a lack of this donative intent that might be inferred back to 2011. There is evidence he has a sworn affidavit. And his sworn affidavit says he never used any of the money for his personal use, and he did not consider it to be his money. He was willing to take whatever steps it was to transfer it to them. Why doesn't that create an issue of fact?
So I guess two layers to that answer. I guess first turning to the standard of review. While the district court did frame its decision as a summary judgment decision, and while he asked for summary judgment type briefing, if you look at what the district court did here, under either the government's view or appellant's view, this was either a motion setting terms of a supersedious bond, that's the United States view, or as appellants contest, this is effectively a denial of a motion to quash a writ of execution. But under either of those views, this court has case law indicating that those decisions, those kinds of decisions, are discretionary ones, committed to the discretion of the district court, and are reviewed for abuse of discretion.
Mr. Starcher, it's true that that the Lutz case was prejudgment. Now it's post-judgment. Does that have any effect on the finality issue?
It does. The reasoning of the Lutz case, I guess, to focus on that the argument in Lutz was that those, while not final judgments, were still appealable as interlocutory appeals under the collateral order doctrine. That's not an argument that's right here. There isn't an argument that this is appealable as a collateral order. But the reasoning of Lutz was not specific to the timing with respect to that issue. This court in Lutz said that the reason why the collateral order doctrine was not available was because the issues raised in the Lutz appeal, similar to the issues raised here, were not significantly important, which is one of the requirements of the collateral order doctrine, and important in the sense that the issues being raised in Lutz, just as here, only relate to individuals' property interest in specific accounts. So in that sense, even though you're correct that the Lutz was prejudgment attachments, the reasoning of Lutz also disposes of any suggestion here that a collateral order doctrine would be available. But to return to to Judge Wynn's question, assuming that you were to reach the merits and to find that you had jurisdiction, again, this court has held, and this is an unpublished decision was the only case that I'm aware of here, but in United States versus LaRoque, that's 724 Federal Appendix 268, this court held that a motion to quash is subject only to a decision denying a motion to quash is subject only to an abuse of discretion standard, and that's citing a published decision, United States versus Under Seal. So I think even though this was framed as a summary judgment type briefing, I think what the district court was getting at here was it was trying to decide whether or not it could resolve these questions on the papers, and whether or not it needed to conduct an evidentiary hearing.
So your view is, even though the government moved for summary judgment, that this is not relief that was granted based upon summary judgment to you?
That's to be clear about this, the district court asked the parties to file summary judgment type briefing on this question, and so the United States filed what it was asked to file and asked for summary judgment, citing the summary judgment.
Why would it do that? Why would it do that if you say summary judgment is not an issue in this case? Why do you need summary judgment?
I don't think we do need summary judgment. I think that was the standard invoked. And to give an example here that I think clarifies this point, suppose that the district court was making a finding of fact and it said, I have to find a certain fact by clear and convincing evidence. and it says that that standard is met. And then the case comes up on appeal, and it turns out the district court was wrong. It only had to find that fact by preponderance. This court wouldn't send the decision back to the district court because it had asked, it had applied a higher evidentiary standard than it needed to. And I think that's what happened here. The district court held itself to a summary judgment type standard and found that standard met. But this court's case law is clear that these sorts of decisions about motions to quash and supersedious bonds are the sorts of decisions that are entrusted to a district court's discretion. And so despite the framing of the briefing and the decision, the United States position is that the appropriate way to view this.
Well, if it used a summary judgment standard, what was that? Isn't that a light most favorable to the non-moving party? There's no disputed evidence?
So to turn and squarely address Your Honors, assuming that summary judgment is the appropriate standard here.
I'm only going upon the motions that at least what was there, that this is what the trial judge did. I mean, if you say use of summary judgment standard, that's all I'm saying. It's not an assumption. So I don't understand that. If it's done using the summary judgment standard, that's pretty set forth, pretty much standard. So if that is used, then the question is, why is that not a disputed fact in this matter, at least because of his affidavit?
So appellant's position that the district court somehow disregarded the affidavit, and you can look at that affidavit yourself, it's in the record, is undercut by the district court's own decision. The district court clearly did look at this affidavit. It is true that in the course of the affidavit, Mr. Dent says that when he opened the accounts for Hunter and Haley, his two children, his elder children, he said the purpose of these deposits was to help my children pay for educational and other expenses when they became adults. And then at other points in that affidavit, he says, I view this money as their money. But that affidavit also, very importantly, as you noted, as was noted in earlier questioning, that affidavit also admits repeatedly to engaging in conduct that is fundamentally inconsistent with that kind of donative intent. And the case law that appellants cite, this is the Dubinsky. So
you got some evidence that goes one way and some evidence that goes the other way. You have an affidavit in a light most favorable points in a particular direction that seems to favor him.
I would disagree. I think this court has made clear that when you're even under a summary judgment standard, certain things are not enough to create a material dispute of fact. And among those things, self-serving statements of a party, also contradictory statements. And I think if you look at the affidavit in its entirety here, Mr. Dent, said these things about what his intent was, sort of in a conclusory fashion. He said, I intended this money to be my children's. But then he later on in that same affidavit repeatedly said things that are inconsistent with that intent. Again, appellants suggest
which is what? I mean, I'm saying in the light, when you look at it, he says, I never used any money for my personal use. He didn't consider the money to be his. And he said he was willing to take steps to give it back.
So to be clear, there's no requirement. The whole question here is whether or not there was donative intent over these funds.
Well, let me ask you that in that regard, talking about Dent's substantial non-exempt interest, the court applied the control test in the first instance rather than making a finding of indefeasible gift under South Carolina law. Was that an error?
No,
Your Honor. Use the control test? Use the control test?
I'm not sure whether or not the way that the district court approached this was reasonable, which was that it first asked the question whether or not the United States had made a showing that Dent had a substantial interest in these monies, and the United States had made that showing based on all of the evidence of control that it had put forward. And then at that point, appellants said it was their burden at that point to show that despite that, the money was not in fact Mr. Dunt's, and that the children in fact had ownership over this money. And when it came to that, again, the evidence before the district court on this issue was undisputed that Mr. Dent had engaged in extensive conduct that was fundamentally inconsistent with the idea that he viewed this money as a completed, perfected gift to to his children. And again, this
I mean, but what's the whole purpose of the South Carolina Uniform to Gift of Minors Act if he makes a valid gift to them?
Yep.
If he gives them this money, then how does he have a substantial interest in the bank accounts?
So the key word there, Your Honor, is valid gift. And so there's the case law is clear that under the UGMA, it's not enough to merely invoke the statute. Invoking the statute creates a presumption of donative intent, but not an irrebuttable one. And as questions sort of in the first half indicated,
weren't these accounts initially set up in compliance with the Uniform Gift Act of South Carolina? And weren't they maintained? He was set up as a custodial manager of it. And from your perspective, that even those accounts, and it's kind of interesting to understand that what you are saying is that a custodial manager, at the end of when the person becomes 21, there are reasons why you have this Uniform Gift Act, tax reasons and other reasons. And I'm trying to understand how it is that you can convert that money back to yourself when they get 21, when it's been set up as a valid gift at that point.
So again, the key there is valid gift, and that was the question before the district court, and it's a question presented here on appeal. The question, there's no dispute that in order to invoke the protections of the UGMA, an individual has to give a gift, and part of giving a gift is that at the moment they give over that money, there has to have been donative intent. In other words, intent to surrender dominion and control over the gift and to indefeasibly and finally give it to the giftee. And so that's the question, whether or not this was ever, in fact, a valid UGMA account. And it has the name on it. It was created under the title of the UGMA. But in order to have a perfected...
It sounds like to me that if a child has one of these, is a beneficiary of one of these gifts, that you could go for 10, 12 years, and when you hit 21, you have no rights. Is that right? In other words, you have no rights. You just have, because the custodial manager just took your money and ran away with it. Is that the case?
If a court finds that the custodial manager never intended...
No, I'm just asking you straight up. You don't need a court to find that out. I mean, if based upon what you're saying is that as the custodial manager, you're not obligated to comply with anything you've already set up on this thing for all these years, that when they hit 21, you can just take the money and use it for yourself if you want to.
I see. I mean, yes, that is the implication of the other side's view of this. The implication of the other side's view of this.
That sounds to be your view. That's your view, that you can take the money and do anything else. That under South Carolina law, these children have no rights to this money. Because he can take it and do what he wants to do with it.
Under South Carolina law, if there was no donative intent at the time the gift was created, then yes, the case law is clear that part of a valid gift requires donative intent. And courts have recognized that one of the ways...
Wouldn't it be evidence of a donative intent if you set up the account, you maintain it for years, and you comply with all of the requirements for setting it up until 21, and then all of a sudden you take the money? I mean, I don't understand that.
Respectfully, that wasn't the evidence before the
court.
But
that would be exactly the case that can happen under your scenario, because it doesn't matter, because there's nothing that indicates he's used it inconsistent, because he's got his affidavit. He says, I never used my personal use. I used it to pay off college loans that I reimbursed myself with. I maintained this account up to this point, and then they hit 21, and I took the money and ran off with it.
So again, I feel like a broken record here a little bit, but if you say that you're opening an account under the UGMA, but when you open that account, you in fact have no donative intent, then yes, that money was never actually gifted to your kids or to whoever else you wanted to give it to. And the district court had before it ample evidence indicating that, in fact, it's circumstantial evidence, but courts have recognized that the treatment of that money during the life of the account is circumstantial evidence of the donative intent that the donee had at time zero when the money was put in there in the first place. And again, I think it bears emphasizing here that Mr. Dent, in his affidavit to the court, made clear and repeatedly acknowledged and admitted that he had done things with this money during the life of the account fundamentally inconsistent with the idea that he viewed this money as his children. So he said, I never viewed it as my own. And yet he admitted that a year and change, I think this is in 2013, after creating his son's account, he emptied that account out and moved all of the money in his son's account, quote unquote son's account, into an account that he'd opened for his daughter.
So who has the burden of proof here when there's an allegation that the debtor lacks a substantial interest, when you have information that accounts were set up in compliance with South Carolina's Uniform Gift Act, maintained over a course of years, and then the children then come up and says, this is our money that he has or whatever. Who has the burden here when that argument is made that he doesn't have a substantial asset in our money?
When an asset is subject to a writ of execution or a supersedious bond or is otherwise implicated in judgment enforcement proceedings, and these accounts were subject to a writ of execution, when an asset is subject to a writ of execution and a third party wants to come in and demonstrate that the asset should never have been so treated because it was in fact owned by someone else, the individual coming into court and trying to remove that asset is the party that bears the burden of showing that they have ownership and that therefore that asset should be removed from the writ or the supersedious bond or what have you.
Well, that kind of puts the cart before the wagon, because the question is, if you went and got a third party's money, you could go and get anybody's money without this and just say, okay, this is an asset. Now you're going to require them to say he doesn't have a substantial interest in it. Why wouldn't the government take on the proof that sounds like it's reasonable? Okay, you seize the asset, now show that he has a substantial interest in that account.
Just to be clear, the United States has not executed, the money is not with the United States. And
I'm only trying to be clear on the burden of proof here. I know we can play it. I'm not trying to get around the words. I'm trying to get to the issue that I want to hear the answer to. And that is, who has the burden of proof when a third party says that a judgment debtor lacks a substantial interest in this property? Why isn't it reasonable that comes up and says, oh no, he has a substantial interest, I'm going to get it. The government then says, I'm going to show you he's had his interest in that property. Or is the burden of proof on the, I guess the burden from the third party perspective, you say they have to then show that he doesn't have it.
Right.
So that sounds to be flipping things around to me.
So the initial burden is on the United States to show that there's a substantial non-exempt interest in the money. That's what allows it to be subjected.
So the burden is on the government to show that the judgment debtor has a substantial interest in this property.
A substantial non-exempt interest. Yes, that's the.
Yes, it is not on the third party to show that otherwise. It's not on the third party to come in and show that he doesn't have it. It's on the government to show that he does have it.
Once the United States has made it showing that there's evidence to support a finding that there's a substantial non-exempt interest, and here that evidence was substantial. Mr. Dent, sole signatory in the account, only individual.
I got how you characterize the evidence. I'm just trying to understand the burden of proof side of it. That's
right.
So, as long as the focus is first on the government, someone says, no, you took my property. You then says, no, it's not your property because he has a substantial interest. Then the government has to prove he has a substantial interest in the property. At that point in time, once you do, if you got a defense would be, no, he doesn't. I got that.
And just to highlight that, these same interests, individuals coming into court and saying, this was in fact my property, you can't include it in this litigation. These were the exact issues that were raised in Lutz. There too, this case that came up to this court, several years ago. There too, it was third parties coming in saying that they had certain interests and certain assets that had been subjected to prejudgment attachments. And there, this court had no trouble finding that there was no jurisdiction even to hear that appeal. And as the same outcome should be reached here. There's, as Judge Motz highlighted earlier, the only reason why the main liability judgment was properly before this court on appeal was because the district court had issued a 54B ruling certifying that. There are still claims of the United States that have yet to be litigated. This money is currently being held in a supersedious bond in the court's registry account. And so there are multiple inflection points moving forward at which things can change in this case, and at which appellants could at a later time assert these same sorts of issues, these same sorts of concerns. They could actually move to quash a writ of execution at some point in the future. And so this is not a final judgment.
Along that point, can I ask you, when I asked your colleague on the other side about this, she said that this was in effect the denial of a writ of execution. Would that be a final order?
It can be under certain circumstances. I guess two layers of, I know I'm over time, but I'll answer this question, obviously.
I have two more too.
Okay, so I'll start here and then keep going. So the case that appellants cite, this Parker case out of the Fifth Circuit for the proposition that motions to quash writs of execution can be final orders. That case makes clear that in all events, when asking whether something is final, motion to quash or otherwise, the key question is whether or not there's anything left for the district court to do with respect to the matter. And so here you need to look no further than the district court's order to see that there are still things for the district court to do with respect to this money. If you look at J 1344 to 1345, the district court made clear that the issue before it was whether or not these bank accounts are assets subject to a supersedious bond, not finally resolving the question of ownership. The order.
Okay, I'm sorry, you are on time and it's been a long day. Yes, so let me ask you my two other questions, which are both fact questions. I don't think everything won't be long. The Dent children represent that the government still has not returned the funds to LD. Is that correct?
The LD account funds are in the district court's registry. So the United States doesn't have those funds, and in the United States view, that's Mr. Dent presumably can go to the court and get those funds released from the district court's registry. But in the United States has no role to play in that anymore. The money isn't with the United States. It's with it's
the Dent children also, this goes to the facts which we're talking about with my colleague, but the Dent children also dispute whether Dent was made aware, ever made the children aware of the custodial account.
So notice was provided to Mr. Dent, and under anyone's view of this, these accounts, the names of the accounts were Mr. Dent as custodian of the children, and so making the custodian of these accounts aware that they were going to be subjected or could be subjected to these judgments. In the United States view, it was sufficient to also give notice to the individuals who the custodian was managing these accounts for, or claimed to be managing these accounts for.
Okay, thank you. Do my colleagues have any further questions?
No.
No.
Thank you.
Is there a rebuttal?
Thank you. One point that I want to discuss is the idea of control. So it is true that there is a control standard that is utilized here, but it is not just what a debtor controls that is here. It is property of that the debtor has a substantial non-exempt interest in. If the debtor controls property that doesn't belong to him, it is simply not subject to a writ of execution. The substantial non-exempt interest is a lot more of the burden that the government has. They did not just have to prove that Dent controlled this money. In addition, I want to point out that the names of these accounts actually have the children's names first, not Mr. Dent's. It says Haley Shannon Dent, Floyd Dent, custodian. And the government was well aware of the ages of these children as shown in the evidence. They were well aware they had been conducting discovery on Mr. Dent for over 4 years in his financial condition. They had absolutely every reason to know that both of these Hunter and Haley were over the age of 21. The South Carolina UGMA is clear that custodianship does not extend past that point. They had every reason to know that these two individuals who are not their father should be notified. And the government has the responsibility to give notice to every person that it has reason to believe has an interest in those accounts. And why they did not give notice to my clients is beyond me. The fact that they gave notice to Mr. Dent, in addition, doesn't say that these specific accounts were going to be levied. It said the writ of execution was extremely broad. It did not list these accounts on the writ of execution. There was no way for him to know that these accounts would be seized, especially since under the UGMA, these funds belonged to his children. Now, the district court did disregard Mr. Dent's affidavit as self-serving, which is what the government had argued. But I want to be clear too that the self-serving affidavit idea is only for self-serving opinions that are self-serving. cannot be credited to a litigant. But in this case, this was not a self-serving affidavit. This was an affidavit that was serving his children, which means it's not self-serving, and that he only testified in that affidavit to one instance that was an opinion, and that was his opinion at 18 that his son was not quite ready to have the responsibility for this money. And that opinion is something that he is in his duties as a custodian is required to make under the UGMA. That is his job to determine at the age of 18 if his children or the other minors, if it wasn't his children, are responsible enough for these funds. That is why the UGMA allows the custodian the discretion to determine at 18 or 21. Now, Mr. Starcher keeps mentioning the idea that Mr. Dent repeatedly violated the UGMA, but I do not see that reflected in the record. When Mr. Dent took the money out of Hunter's account, he put it in a comparable account that he could easily put it back. He kept the account open and he deposited additional funds. There's no evidence in the record that would indicate that he thought that that money could be Haley's. And even if he did, the fact that he thought, if he had thought that the money was Haley's, that he could give it from Hunter to Haley, that doesn't necessarily mean that Dent used it for his own purposes. There is no evidence in the record whatsoever that Dent ever took a penny of that money for himself. And the treatment of money by a custodian after donative intent has been established that Mr. Starcher was referring to, the case law that says that donative intent can be defeated by later acts, all of those cases that we read and we briefed said that that custodian had to treat that money as if it was his. So, for example, somebody putting money into an account, a UGMA account, and then immediately taking it out and giving himself a business loan or buying a truck or something else like that. So the treatment of the money has to be for the custodian to defeat the gift. There's no evidence that these gifts, that there was nothing but donative intent in 2011 when these gifts were created. And Mr. Dent's affidavit is an affidavit filled with factual assertions backed up by evidence, which has been uncontroverted in the record. If we do determine that the burden of proof in this case is that the government has to prove that Dent has a substantial non-exempt interest in property, the government simply has not met that burden of proof.
What is our standard of review?
It is, as we've discussed, a kind of a complicated thing because we briefed the issue to summary judgment. So
we probably need to uncomplicate it. We need to uncomplicate it since we got to figure out what it is. So what is the view? Well, what do you say it is?
This was cross motions for summary judgment. And with cross motions for summary judgment, the appeal, this is a de novo standard. This was the district court decided as a matter of law that there was no genuine issue of material fact. We say that there's no genuine issue of material fact that these funds are our clients. The government says the opposite. So it should be a de novo review.
Well, that's a really, really simplistic answer that I don't think really deals with Judge Wynn's question. You started out recognizing that there are all kinds of arguments that this really wasn't summary judgment. So, but you decided you would just go ahead and say that because it looks like summary judgment, I'll go with that. Believe me, Judge Wynn knows the standard for granting summary judgment. So that's all you need to say with respect to that. But really what we wanted you to explain to us is why it's that we should look at rather than some other standard.
I think in this case, because there was an opportunity after the district court had said that if the summary judgment did not clear up the issue, there could be an evidentiary hearing. I do believe in this case, the summary judgment standard is correct because there was never a full factual weight. There was never a full evidentiary hearing. There was never a full measuring of the facts, which could show in which abuse of discretion could be applied to, which is why I say standard summary judgment. But even if it was abuse of discretion, the district court would have abused discretion as to the weight of the facts. And I see my time is almost up. Are there any more questions?
I don't think so. Thanks very much.
Thank you.
Appreciate your argument.
Thank you.
And we will adjourn court for the day.
Thank you.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.